Well, hello, friends. Welcome to Uncivil Law, and I hope you are having a fantastic Christmas. And we are here with some continuing tea, and we are here with a celebration for the channel. The channel has crossed 19,000 subscribers. Thanks to many of you, we have picked up enough subscribers over the past couple of days to pass the 19,000 mark. And with a little bit of luck and a little bit of good fortune, we might be able to cross 20,000 by the end of the year. I mean, it is a week away. So we have 7 days. So that's a lot of aspiration to pick up 1,000 subs in one day or in 1 week. But we'll see if we can pull that off. That would be really cool. But even if we don't, we passed 19,000 subscribers. So that was really fun. And I'm very happy, obviously, about that. And I just wanted to say thank you. Last time we left the action, I decided, for reasons that I don't know why I thought it was a good idea, but I did. I thought it was a good idea to try to do a discussion of the Toddy Westbrook reply to the motion to dismiss as soon as it came out. That was filed around 11:30 Western time, which is around 1:30 a.m. my time. So we started around 2 o'clock, and then we streamed for 2 hours, I think. I think I got to bed around 4. It may not have been the most successful stream of all time, but you guys seemed to like it. It was one of my more popular streams. It was one of my more successful streams. One of the ones that had the higher watch count and the higher retention rate. So you guys seem to like it, whatever problems there might be. But and so in the spirit of honoring you, and the spirit of honoring your watching, I decided what we should do is we should go back. We've done the core of the thing. We did the actual response. But now I thought what we could do is we could spend some time on all the declarations. So there are 4 different declarations, and I thought what we could do today to celebrate Christmas, a last-minute Christmas gift to all of you. How about some more tea? How about we discuss the 4 declarations, see what they have to say, and just go from there. Now, I'm not expecting there will be a whole ton of legal analysis in this portion of it, because the declarations are statements of fact or proposed fact. These are the people who are writing them saying these are the facts as far as I'm concerned. So there may not be a lot of legal analysis, but there might be some. But we will read it and see what it has to say for whatever value it has, however little it might be, and we will go from there. Sound fair? All right, fantastic. So that is what we are doing today. So, yeah. And this is not a Fiverr background, but it is one that I have found that I think is working for me for the moment. So let us do that. I did try to commission one on Fiverr. I paid someone to create a custom one, and they came up with stock photos. So that didn't work out so well on Fiverr. But I thought this background was pretty good. So anyways, let us just go back. Susan gives me $9 Canadian to say Merry Christmas. Well, Merry Christmas to you as well, Susan. I hope you're having a fantastic day. So let us read these declarations. We'll read Toddy's again. We covered it last time, but we'll read it again because by the time I got around to Toddy's declaration, I was pretty tired and may not have been 100% lucid. So we'll just give it another go. That sounds fair. So let's do that. So let's start with the declaration of Tatiana Westbrook, and we will read it again. So she says that she's a resident of Washington, born in Washington. Her personal bank accounts are in Washington, owns investment property in Washington. Her business and banking accounts are in Washington. She does not own or rent any property in California. She did own/rent property in California at one point in the past because she rented that place in LA that she may not have ever lived at, but she did rent there, but maybe she doesn't now. But then again, we'd have to wonder about various time periods. She owns Toddy Halo. Part of her business involves critiquing people on social media. She has her channel called Glam Life Guru. Exciting. I probably need some of that glam life. I don't know. You guys can tell me, how glam am I? On a scale of 1 to 10. How glam? Do I need more glam? Because I have so much followers, I am highly recognizable. For my personal safety, I don't know where I want the general public to know where I am. As part of my work, I travel around the world and post pictures. However, I often post videos and pictures at random times while I'm not at a location, so people do not know where I am or where I live. Well, fair enough. But a person at least has a cognizable basis for any photo that you post under your name to think it is you and it is what it purports to be. So it may not be what it purports to be, but a person could reasonably think it is what it purports to be, that it is of this location, it was posted at is of this time, of this location, and it was posted by you, right? That would be a reasonable conclusion to draw. It would also be a reasonable conclusion to draw that one or more of those things are not what they purport to be. But, a person doesn't know, because you don't have any method of indicating, as far as I'm aware. You don't have any method of indicating, like in the tweet or in the Instagram post or otherwise, to say this was posted by someone else. This was authored by someone else. So someone would reasonably be able to think this was posted by you at this time of this location. That may not be true, but a person could reasonably believe it's true. A person wouldn't be acting recklessly to believe that it is what it purports to be, right? So she's about to say, well, this is an evidence of me. I'm like, yes, it is. It is evidence. It may not be true, but then again, a lot of evidence may not necessarily be true. But it's evidence. I mean, it's saying something. $4.99 from Rachel. Hugs and kisses from the UK. Merry Xmas. Can't wait for you and Nate and Emily to have a panel debate. I love it when you talk about tea. Makes me laugh. Excellent. I'm happy to make you laugh. I am excited that I can serve that role for you. I was born and raised in Washington. Much of my family lives there. For a period of time, I lived in California, but we started to move to Washington and signed a lease agreement for our new home, and officially took possession of our home on December the 1st. I don't know exactly what take possession of. Is that the closing date? Probably. It doesn't necessarily mean that's when she started to live there. It probably means the closing date. May not necessarily be the date she started to live there. So there's a true and correct copy of the redacted version of the current lease to our home in Washington, includes the extension of the lease through March 2021. Okay. My husband and I also file personal federal income tax returns in the state of Washington and can provide a copy of those to the court. Fine. Below is a screenshot from February the 18th, 2019. The picture in the Instagram post was taken of me in my Washington residence. As I demonstrated in the picture below, this is one of many social media posts of pictures I obviously didn't take myself. Well, it's not obvious you didn't take it yourself. I mean, it could be on a timer, right? I mean, there's no immediate reason to think that you didn't take this photograph. Obviously, you're not holding the camera, but you could have taken this photograph. You could have a camera trigger in your hand that you're concealing. It could have been on a timer, right? So this could have been taken by you. And when you post things on social media on your account, people have a reasonable belief to believe this they can believe it was taken by you, it says it's posted on February the 18th, so they can believe it was taken on that date, and they can believe that it was posted on the time. And of course, they don't have to believe those things, but it would be reasonable to believe those things, right? And you are attempting to convince people it is true, right? You're attempting to convince people it was of this place, of that time. I mean, that's part of the goal. And it may not reflect reality, but people have a reasonable basis to believe in it. You can't be reckless for thinking it's true. So it's like, well, it's obvious it wasn't taken by me. It's not that obvious. Defendants in this case have published approximately 80 videos of me, my husband, and my business. In a video titled Whatever, I know to be Katie Joy Paulson states, starting approximately 6 minutes into the video, defendants started digging into my family's background, looking all over the place, everywhere. Defendants go on to state, starting at approximately 9 minutes in, the video in that used several different searches because the site called Truth Finder is a very basic background check and doesn't have everything. Defendants indicate in this video that you can go state to state and pull stuff up as well. Fair enough. Which is why what they said they did to get personal information about my husband and our family. To the extent it's public record, sure. My husband has downloaded a true and correct copy of this, which we put in a Dropbox video. In another video, approximately 3 minutes into the video, a person I know to be Katie Joy Paulson began discussing the defendant's investigation into me and my husband. Starting approximately 13 minutes into the video, defendants talk about the research they've done into my childhood and my family in Washington. Defendants discuss my sister and mother, all of whom are private citizens. Fair enough, but as long as we're not telling falsehoods about them, then, that's fine. You can talk about private people, you just, can't defame them. For that matter, you can't defame people in general, but they also discuss my personal history in Washington. Starting at approximately 55 minutes in the video, defendants also state they have documentation for all the information in the video, including court records from Washington State they found through 3 weeks of nonstop research to find all that information. At approximately 56 minutes in the video, defendants thank their viewers for sticking with them in their two-part expose, and they can uncover more information to deliver to viewers. And we've downloaded a true and correct copy of this as well. So this might be helpful. This might be helpful to the harassment issue. This might be helpful to the, so this is like, with the bitter comes the sweet, with the good comes the bad, and maybe you don't get things for free. All right, so this is helpful to the harassment cause of action. This might be helpful to the negligent infliction of emotional distress cause of action. This might be helpful to jurisdiction, but it is unhelpful to defamation, because even in public figure, and Toddy herself says how she's recognizable and well-known and stuff, so she's all but conceding she's a public figure. So if she's public figure, then we have to have malice to get to the standard, right? If you defame a private person in a private matter, you just need to show negligence. Negligence is your minimum threshold. So you need to show negligence in making a false statement. If it's a public person, then we elevate that standard to the malice. You have to show that you actually knew it was false, or you recklessly disregarded the truth. So the way I always like to phrase it is malice to the truth. That's the way I like to phrase it, because it's not malice to the person. That's a mistake. It's not malice to the person. It's malice to the truth. So it has nothing to do with I hate you. That has nothing to do with it. It has to do with I'm ignoring the truth. So my hatred is to the truth as such. That's the way I always like to phrase it, because if you're thinking malice and you're thinking hatred to the person, you're on the wrong track. So when she's doing all this and she's saying, well, look at all this research they did. They went into my background. They went into my family. They pulled records. They made these videos. They made these exposés. They did court research and so forth and so on and so on. Like, it's building up the harassment. It's building up the emotional distress, but it's hurting her case in the defamation, because it's like, how negligent can I possibly be when I did this extremely thorough deep dive research, So it's like, yeah, with the bitter comes the sweet, with the good comes the bad, nothing comes for free. Unfortunately, of course, KJ never actually moved to dismiss the defamation cause of action, so it doesn't really matter for today's purposes. But if KJ had moved to dismiss the defamation, this would cut both ways. But since that didn't happen, it only cuts one way, because KJ never moved to dismiss the defamation, because we don't believe in it or something. I don't know. Okay. But, this is the stuff you have to think about, because this is cutting both ways. And then she declares under penalty of perjury that various things are true. Okay, so that's the end of Toddy's declaration. Let's move on to James's declaration, which is the longest of the bunch at 55 pages. Can I take some questions before we move on? We'll do some little Q&A about the stuff we've covered so far. If there's some legal questions, or you need me to clarify something, right? So I'd be happy to clarify. And I'll just skim real fast to see if there's any questions so far or stuff. I won't read them all, but I'll just see if there's anything going on so far. Jurisdiction arguments are a bit confusing, but there's possibilities there. Lol, you're glam. Are you strawberry blonde or ginger? Well, depends on your point of view. You tell me. Comes us more strawberry. Yeah, I think probably more strawberry blonde than true red. But it's a shade of ginger, I think. When are you and Emily and Nate doing it live next week? We have no tentative date, but I'm pretty open. So, whenever. Maybe Wednesday. Nate and I have a standing thing that we do on Wednesday nights. So that would be the most logical thing, to do it Wednesday, because Nate and I already have a thing that we do on Wednesdays. So we just pop over to her channel for a week instead of doing our thing already. So that'd be my vote. I bring a different perspective. Yeah, much appreciated. This is what Emily was talking about too in some of her streams, that she really likes it because we all think about things a little bit differently. We all spot different issues and we all highlight different things. So, it's one of the benefits of having a lot of people who are educated in the field, because we all think about things a little bit differently. We all prioritize different things. Like, in my analysis, jurisdiction is not as important into my analysis as it might, and someone else might pop on that issue, but it's not as important to me. As we think about things a little bit differently. I always kind of like to run to the end of the page, so I always like to try to get to the ultimate issue. So jurisdiction isn't the ultimate issue. That the ultimate issue is the liability. So I always kind of like bypass the intermediate issues, and I always like to get to the more core issues, or at least what I perceive more core. But different people think about it differently, and some lawyers probably think jurisdiction is very important, I'm sure. Would the research in Washington go to jurisdiction? Unclear. Have I ever watched Emily's video breaking down the response from yesterday? I did see her video. I thought it was very good. Did extensive research be used to prove malice to the truth? I think it cuts the other way. The extensive research cuts the other way. To say that you have malice to the truth is to say that you know it's false, or you should have known it's false. Reckless disregard. You recklessly disregarded its falseness. If you're doing all this incredible deep dive research and you're pulling birth certificates and you're pulling marriage records, you're pulling death certificates, you're pulling all this document, you're pulling court records, like, if you're doing all that deep research, it cuts exactly the opposite way. I mean, how much malice to the truth can you possibly have when you're doing incredible amounts of research? So it's like, I was trying to find out the truth. Look how much I did to try to find out. How reckless can I possibly be? If I had to pick a side to represent, who would I prefer? If I had to pick a side to represent, well, KJ needs the most help. And I always do like the underdog. So I'd have to go with KJ. I do like the underdog. I do like the scrap. So yeah, I'd have to pick KJ to represent, because I do like the slightly disadvantaged position. Do I think KJ is screwed at this point? No, I just think that she has problems that are not necessary. Do I think an attorney wrote the motion to dismiss? I mean, it feels like it was written by an attorney. The language feels written by an attorney, so. But it had a lot of problems in it, so, whatever. What if she said all that, then lied on the truth? Well, that would be knowingly telling a lie. If she did all that, that would be the alternative, right? So she can't be reckless, but if she knowingly lied, then she's there. That would be malice to truth. So if despite all that research, she said something actively not true, then she'd have malice because she knowingly lied. But you don't usually see that in a defamation case. It's not unheard of, but it's a bit unusual. Usually you're thinking about recklessness, the other half of the equation. It's a bit unusual to catch someone in an out and out lie in a defamation, that they really knew it and they said otherwise. So you don't normally expect it, but I guess it's possible. If you say something that's untrue after doing all the research, wouldn't that be malice? It depends. Do you know it's untrue? Right? If it's untrue, you have to know it's untrue. So yeah, if you did all that research and you still said something was false, it's like, did you know it was false? I mean, I thoroughly looked, but I still came to the wrong conclusion. I mean, just because you did all the research in the world doesn't mean that, you know for sure what's true. But it does mean that you tried, and that's enough, right? Yeah. So yeah. All right, that's cool. What if she lied about doing the research? It doesn't appear that she lied. I mean, Toddy herself is saying the research happened. That seems to be what Toddy is saying. Toddy seems to be saying that all this research did in fact happen. If I'm reading her declaration right, that she pulled records and pulled things and stuff like that. So it doesn't seem like she's lying about that. And Toddy doesn't seem to think that she's lying about that, as best as I can tell. That's part of the harassment element, right? That's part of the campaign of harassment, that she did in fact do all those things. So Toddy doesn't seem to think that that's a lie, as best as I can tell. All right, cool. Let's move on to James's declaration. She lied about having channel members in Washington. I'm not really sure that's a lie. And here's why I think that. And you have to think, for something to be a lie, you have to know when you're saying it that it's not true. You have to actually know when you're saying it that what you're saying is not true. So is it possible that she one time on a stream saw someone was from Washington and said, "Hello, I'm so happy you're here from Washington," and then forgot that happened. I mean, yeah. I mean, I do streams all the time. All the time. If you think that I remember every single thing that I read in a stream, or even everything that I acknowledge, if you think that I remember every single thing I read, or even everything I put on camera, you're out of your mind. I do a lot of stuff. You think that once I read it, even if I repeat it on screen, that I will 6 months from now remember that I read that and remember that I said it? You're out of your mind. I might remember some of it, but would I remember all of it? No. And I think that's an unrealistic expectation. I think it's just an unrealistic expectation to think that people have perfect memories. So do I think it's possible that KJ saw that someone was from Washington, openly acknowledged that, said, "It's great that you're from Washington," and then later when she said, "Do I have any channel members from Washington?" she said, "Not to my knowledge." Do I know that's a lie? Hell no, I don't know it's a lie. I don't know it's a lie. And if I had to bet, I bet it's true. Or I bet she didn't know it was false. Because it's like, do you really expect her to remember every little thing she said and every little thing you read? People aren't like that. People are not tape recorders. People do not have that perfect memory. Do you remember everything that you had? I mean, do you even remember every conversation you said today? Let's just go to today, because a lot of you might be with family. Do you really remember every single conversation you said? Do you remember everything everyone told you in those conversations? Do you think it's possible that someone told you something today that you've already forgotten about? Yeah. So 6 months from now, if someone asks you, "Hey, did Uncle so-and-so say this?" and you say no, does it mean that you lied, or does it mean that you immediately forgot it and yeah, you don't remember that happened? So do I think that she was lying when she said, "I don't have any members from Washington"? I don't. Because I wouldn't expect her to remember it, because I wouldn't expect me to remember it. So, yeah. That's what I think about that. Hello, Rich Lux. Nice to have you here. All right, so let's see what James has to say. He's a resident of Washington. He has a driver's license. His bank accounts are there. Business accounts are there. His citizenship of the companies is easy to find. For a period of time, they lived in California, but started to move in Washington late 2018. Signed a lease agreement and took possession of our home on December the 1st. A Merry Christmas to everybody, of course. My wife and I also file personal income tax returns in Washington and can provide copies of our tax returns for Washington review in chambers. We filed our personal federal income taxes and also plan to do so in 2020. Due to the financial, we do not wish to make them return. That's fine. Chief Operating Officer of Halo. There are several ways in which businesses or individuals with with YouTube channels can earn income. These methods include sponsorships, affiliate commissions, merchandising, AdSense revenue, memberships, and super chats. Lucrative sponsorships and affiliate commissions are usually available to very large channels with high viewership. I'm still waiting for my offer from Raid Shadow Legends. Let me tell you about this wonderful new game hitting the internet, Raid Shadow Legends, and how wonderful it is. Anytime, man. $5 from Kentucky Girl. Love your baby blues and your brain. Merry Christmas. Merry Christmas to you, to you, Kentucky Girl. You know what you should get for yourself for Christmas? Raid Shadow Legends. It's the hot new thing you may not have heard about. Also, I'd like to tell you about the magic of Raycon earbuds. Yeah. Merchandise is somewhat self-explanatory. I've reviewed the Without a Crystal Ball YouTube channel and see that merchandise is sold there. For instance, $9.99 from Rich Lux says, in my opinion, I think Toddy will win. Okay, fair enough. Below is a True and correct screenshot I personally obtained of this channel advertising for sale a Without a Crystal Ball t-shirt that says, "It's just facts." Is she ripping off Emily? Because Emily's on the same page, right? It's just facts, not facts, not fuckery. So maybe Emily and Without a Crystal Ball are more akin than either of them want to admit. AdSense revenue is another way for YouTube channel to earn money from their online content. AdSense works by matching ads to the site based on providers' content and visitors. The ads are created by advertisers who want to promote products. The Google ad team sells ads, takes commissions, and pays YouTube. YouTube channels also derive revenue by encouraging their subscribers to join a private community and become monthly members. For example, $3, $10, or $25 a month. Well, those are examples, but you know who will let you join for a mere 99 cents a month? Yours truly. For 99 cents a month, you can become a member of this channel by hitting the join button on your screen. I am cheaper. I am cheaper than Toddy has even dreamed of, or James has even dreamed of. He hasn't even dreamed of dollar level memberships. YouTube channel owners can easily see in analytics where their subscribers and others view content on a YouTube channel are located by country and even by state. Probably, but I don't normally look to that level of detail, but yes. Furthermore, a YouTube channel owner can drill down in their analytics to break viewers down by geography, location, gender, and age, meaning a YouTube channel owner can, if they choose, easily see how many females between ages of 18 and 45 that live in such a state as Washington have viewed a particular video. I'm not sure if you can get to that level of detail or not. I know you could do like females between 18 and 45. I'm not sure you can also like select them additionally by state, but I haven't tried that much. Tifa Tot said, "Much love on Civil Law. New sub here. Love the live with Katie D. Barker. You seem wonderful." I am in fact wonderful. I am all the wonderful. Yeah. Likewise, one can see each individual country from which subscribers and viewers are derived. I believe that's true. Different countries have different CPM rates for AdSense, but the United States is one of the most lucrative. For instance, on or about August the 30th of 2020, on the Without a Crystal Ball channel, in a video entitled "Whatever," a viewer from Washington said hello in the video chat, and a person I know to be Katie Paulson at approximately 1:20 said hello to Patricia from Washington. That probably happened. But the expectation that Without a Crystal Ball would remember that is a little bit absurd. I mean, come on. It's like, yeah, do you think I remember every YouTube comment I read or even say on screen? No, I do not. That would be a little bit weird if my memory is that good. So someone's going to someday accuse me of lying or committing perjury because I'll say something didn't happen, and then it turned out it did. And they'll say, "You're lying. You knew you were lying the whole time." Like, yeah, my amazingly memory is not infallible, so not really a lie, no. So this video can be found wherever. Thus, any statement that they have no knowledge of viewers or revenue from is simply not true and misleading. Well, it wouldn't be true, but that doesn't mean that it's a lie. I mean, we can demonstrate the truth of it, but the fact that she knew that it wasn't true when she said it, you know, whatever. Hi from Washington State. Oh yeah, she'll definitely remember that forever. You gotta be kidding me. Below was an additional screenshot I obtained from a live chat of another video where someone shows video stating that they are viewing from Seattle, which is in the state of Washington. Well, there are probably Seattles not in Washington. I mean, I wouldn't know for sure, but there are probably Seattles not in Washington. I'm sure. Did you just assume that it was Washington? Hello from Kentucky. Hello from Kentucky. Below is an additional screenshot from wherever showing that viewers staying there viewing from Seattle. Did you assume that? Do you assume that Seattle's in Washington? How dare you assume Seattle statehood? YouTube channels with live streams, such as Without a Crystal Ball, and even more importantly, me, can also gain revenue through super chats, as some of you have been doing while we're talking. And it is always super appreciated. Thank you. I am hoping that at some point I'll be able to do this full time. That would be great. The more of you subscribe, the easier that will become. The bigger the base is, the more that will be possible. So thank you for everyone who's already subscribed, and if you haven't done so, please subscribe. Help the channel grow. I'd really appreciate it. The sum is often viewable to the public watching the live stream, as their comment is highlighted and parked as a top comment for a period of time based on the size of the donation. That's true. Fair enough. We got some people from Houston. Seattle is in Washington. There's some other places other than... No, Seattle isn't only in Washington. Seattle is in Washington. It's probably not the only place this place called Seattle is. Let's just Google real fast and see if we can find a Seattle anywhere else other than Washington. Where else is Seattle? Let's go to Seattle Wikipedia and see. Okay, for other uses, see Seattle disambiguation. There might be somewhere else. So Seattle's Seattle University. Is it the only place in the world called Seattle? Yeah. Well, whatever. You wouldn't necessarily know that, though, because I just had to look it up. So maybe it is the only place in the world called Seattle. Hello, Lady Law, for becoming a supporter. Well, I don't know that I can do much better than getting Law themselves to be a subscriber. Thank you. Barbara Smith, $2. I find this truly amusing. Excellent. I'm very, very happy. That's fantastic. Thank you. Tuscaloosa, Alabama. We got a lot of people. Defendants have made a practice of stirring up drama with the sole purpose of driving clicks and follows. The more dramatic, the more interesting. The more people subscribe. The more people that subscribe and the more salacious the content, the more people watch and the more revenue is earned. I've observed that defendants go live, sometimes several times in a day. Well, I do that sometimes. Just recently, defendants live streamed 7 videos in a single day, some of which were over an hour. It's my opinion that the purpose of these live streams is to get people to become members of the community and in part make money through her lucrative super chat donations so viewers can get in the action of the gossip. I want you to get in on the action of the law. I have personally seen a person I know to be Katie Joy Paulson named Update on Lawsuit, responding to criticism, how to get back, which I've downloaded before they either deleted it or private it, saying that not everything we say as content creators is true. Well, depends what we mean when we said it. I mean, in the most literal sense possible, not everything I say is true because I can't be perfect. I'm going to make mistakes. That doesn't mean that I'm lying. It means that I'm not perfect. So in the most literal sense possible, not everything I say can be true, because if everything I said was true, that would mean that I'm perfect. And as much as I'd like to think I am, I am human and fallible at the end of the day. Once a live stream is finished, YouTube provides the option to either delete or keep the live stream, where it earns AdSense revenue from ads in perpetuity, or until the defendants delete the video, or until YouTube deletes the video, or demonetizes it. Depending on the YouTube algorithm and the number of ads the defendants have, they can earn CPM of anywhere from $3 to $8 per 1,000 views. If defendants save a live stream to their channel in addition to Super Chat, defendant can earn revenue based on AdSense. It's like an annuity that keeps on paying. Okay. It's kind of like a royalty more than an annuity, but whatever. It's basically a production pipeline of drama to milk as much money as possible from the system. We do like our analogies a lot, I suppose. There's only one place in the world called Seattle. Okay, well. So much for there are more than one place called Seattle theory. Oh well. It was a reasonable bet there would be more than one place called Seattle. Oh well. What can you do? See, that would be an example of someone saying something that isn't a lie, but is nevertheless false, right? Because I was like, well, there's probably more than one place called Seattle because it was a reasonable bet. But as it turns out, apparently, that was not true. That doesn't mean that I lied. I didn't lie because I didn't know. But as it turns out, I was saying a falsehood. That doesn't mean that I was lying. which also means that everything this YouTube creator says is not necessarily true. Because here we just had one example of something I just said that is in fact not true, or so it appears. So, when she says content creators, everything they say isn't true, in a literal sense, yeah, because we're not perfect. Sometimes we make mistakes. Right? Jessica says she likes my sense of humor. Fantastic. I'm glad you like my sense of humor. A falsehood isn't a lie? No, a falsehood isn't a lie. For something to be a lie, you have to know that it's false. Yeah, no. Just because, a lie is something you know to be false. So something can be falsehood without being a lie. If you don't know that it's false, it's just false. So yeah, you can have a falsehood without being a lie. Happens all the time. Sure. Yeah. Google the definition. Yeah, that's right. Falsehood definition? I mean, okay, we want to Google the definition of lie. We want the definition of falsehood. Okay, the first definition I see for falsehood is the state of being untrue. And then it gives, so here's what Cambridge Dictionary says. Here's what Cambridge Dictionary, what does you mean? Oh, it's an uncountable. So, according to Cambridge's dictionary, they define falsehood, and they provide two definitions. Falsehood has a definition of lying, and then falsehood also has a definition of a lie or a statement that is not correct. So, a statement that is not correct is not necessarily a lie. In fact, it's not a lie, according to their own definition. So a falsehood is a lie or a statement that is not correct. So something can be a falsehood and not be a lie. Yeah, according to at least Cambridge's dictionary. You want Merriam-Webster? Merriam-Webster, falsehood. Definition 1, an untrue statement. Then provides an example definition, lie. Absence of truth or accuracy. So it's absent of truth or accuracy, not necessarily a lie. So yeah, it can be false, but not a lie. A lie is a kind of falsehood, but it's not the only kind of falsehood. So a lie is of all lies are falsehoods, not all falsehoods are lies. Yeah, all lies are falsehoods, not all falsehoods are lies, according to the dictionary, according to the definitions I find. So there you go. This is the things that lawyers get paid for. Precision. Based on my experience running a YouTube channel, I believe the reason defendants go live so much is that they're the biggest source of revenue. For example, if defendants have 2,000 people giving an average of $5 per month in Super Chat, that would be $10,000 per month. True. And if they receive $200 in Super Chats per video, that would amount to another $15,000 per month. No, that's wrong because you double counted there. But that's okay. We'll give you a break. A YouTube channel's long-term profit motive is to become as big and popular as possible. Because it grows, all the above items scale, and the channel eventually becomes large enough for corporate sponsorships, which can be very lucrative per individual channel. Channels grow by viewership. Big views trigger the YouTube algorithm to promote the videos more, which trigger more growth, which gives more views, which can earn more revenue. Since May of 2019, defendants have published approximately 80 videos maligning me, my wife, and our business. And they've also maligned me, my wife, and our business in 100 internet postings on Twitter and articles on a website called Pathos and on other social media. YouTube takes 30%, not 40%, for whatever it's worth. Unless, of course, you have a negotiated deal with YouTube beyond that. Some really big creators have specialized negotiated deals with YouTube. But for a standard YouTuber, it's 30%, unless it's changed. Others have been sent to private, which means that they can be reset to the public at any time of their choosing in the future. When a video is set to private, no one can see it except for the owner and the admins of the channel. Sometimes defendants re-upload videos that have been removed or made private, so the videos listed below are a list of defendants' videos maligning me, my wife, or my business. And we've seen this list before, so we don't have to reread that because it was in their complaint. Although there seems to be more than there were before. So many videos. In a video entitled Whatever, a person I know to be Katie Joy Paulson states that approximately 6 minutes in, defendant started digging into the background everywhere, looking everywhere. She did several different searches because the site called Truth Finder is a very basic background check and doesn't have everything. You can go state to state and pull things up, which is what they said they did to get personal information. A true and correct copy of this video is wherever. A person I know to be Katie Joy Paulson states my wife and I moved to Washington for tax purposes, which might very well be true. I think a lot of people are not living in California these days for tax/financial reasons, among other reasons. But yeah, moving for tax purposes, although there's probably better choices, but quite possible. She then goes on around 10 minutes in the video to discuss the complaint that was filed by my business partner in Los Angeles Superior Court, in which it is falsely stated that my wife and I are residents of the state of California. But she can rely on that. So, I mean, again, she can use that as a basis for why she said it. So, again, we're talking about reckless disregard for a public figure. So if she's reading a complaint filed by someone else, which is filed in a courthouse, she can reasonably believe it to be true. Now, she doesn't have to. She can believe it to be deceptive or anything else, but it's a reasonable basis to believe it's true. Just like if anyone says anything, it might be a reasonable basis to believe it's true, right? The whole point of defamation is that someone would believe it's true when it's not. So yeah, just because you believe it's true. And if it's in official legal filings, you would think that it's more likely to be true because someone's willing to, actually put it before a court. So you think it's more likely to be true than random statement, I would think. Ween Fain says, honestly, I enjoy him because of his dry sense of humor, much like my own, and how he interacts with people in chat. A lot of other channels don't do that at all or pick and choose who to members. Yeah, I try to talk to as many people as possible, and my channel is at least small enough to allow for that. At some point in the future, it will probably not become possible just from sheer volume, but as long as it's possible, I try to interact with people as much as I can because I think it's good. And there's no way I'm going to remember all those interactions later. But, that's okay. You've downloaded a copy of these videos. One of the false statements contained in the complaint is that my wife and I are California residents. This person knew that my wife and I lived in Washington well before the complaint. As officers of HALO, Mr. Swanson filed corporate documents listing the Washington resident address of me and my wife in the document. In the current video, a person I know to be Katie Joy Paulson showed the document filed by Swanson confirming my residence at the time was Washington. Okay. That document would certainly suggest that. Sure, there might be other documents that would suggest the other thing, but that document would be a basis to think it's true. If there are other documents that say other things, those would be things that say that's true. So, below is a screenshot wherein a person I know displayed the physical redacted screenshot of the corporate document filed by Swanson bearing the residence of my address and myself in Washington. Okay. How do the courts decide if someone's a public figure? Well, there's two kinds of public figure, general purpose public figure and limited purpose public figure. General purpose public figure is pretty hard to get. If you're a general purpose public figure, you're a public figure for all purposes. If you're a limited purpose public figure, you're a public figure for limited purposes. So the easiest way to find out if someone is a limited purpose public figure is if they is purposeful availment into the public, that they are injecting themselves into the public space. So Toddy, with 9 million followers and 9 million subscribers, has got to be a limited purpose public figure. She has made quite some effort to purposefully inject herself into the public space so that people can talk to her. She's living a very, very public life. So I don't know what the magic number is of like subs or views or whatever, but whatever the number is, 9 million has got to be enough that she has purposefully injected herself into the public space. It's not that she was dragooned into there or tricked into there. She is purposely availing herself of the public. So that would be, and then when limited purpose, you're looking at as the limited purposes. So for Toddy, presumably, that would be anything that she is injecting herself into the public for. So that would be her channel, and anything that is the beauty scene would be the easiest one. So that would be like the limited purpose for which she's injected herself. I mean, I don't know her work that much, so I don't know like what other subjects she might talk about or whatever, but anything to which she has purposely put herself into the public eye would be a fair basis. And general purpose public figure is the one above that, where you're a public figure for all purposes. And that's pretty hard. The shorthand way I always say, which is not in any sense a legally binding test, but I just like the imagery of it, and I think it drives the point home. So this is not the legal test, but the uncivil law test for if you're a general purpose public figure is: have you ever been in the National Enquirer, preferably the front page? If you've ever appeared in the National Enquirer, preferably the front page, you're probably a general purpose public figure. That's the kind of thing we're looking about. We're looking extremely high renowned people who A-list actors, big name politicians. Not even every politician probably qualifies as a general purpose public figure, but that's the kind of thing we're looking about. So is Toddy a general purpose public figure? Probably not. Is she a limited purpose public figure? Hell yes. Which purposes? I don't know. We'd have to get into it. But that's how you figure out if someone's a public figure. Have they purposely injected themselves into the public space? At approximately 55 minutes into the video, a person I know to be Katie Joy Paulson also states they don't want to put their addresses out. Not doxing people is always a plus. They don't want to show you where they live. Not doxing people is a plus. At approximately 56 minutes in the video, defendants thank their viewers for sticking with them in their two-part expose. If they uncover more information, they'll deliver it. In addition, I personally reviewed this video titled Whatever, upload to YouTube, where a person I know to be Katie Joy Paulson states at the beginning of the video that my wife and I moved to Seattle actually a while ago, before the September 2020 video. Okay. Defendants also state in the video around 4 minutes in that my wife and I purchased a Los Angeles home and now we're leaving. That doesn't mean necessarily right this second, though. And actually, the purchase was an investment opportunity from an option to buy in 2016. Okay, fair enough. But how is Katie Joy Paulson supposed to know that? I mean, it looks like a purchase the same way as any other purchase. She has no way of knowing it's an investment vehicle, nor would she have any reason to believe that. I mean, it'd be a reasonable conclusion to draw, but not necessarily the most reasonable conclusion to draw. During that time, my wife and I owned the house. We no longer lived in Los Angeles, nor did we even spend a night in the house. Yeah, but Katie Joy Paulson would have no particular reason to know that, right? So we're unclear about defendants indicate when they meant that we're leaving. Well, presumably she thought that you lived there, which would be a reasonable conclusion to draw, since you yourself admit that you did live in California for some period of time. So, I mean, you yourself, both Toddy and you, admit that you did live in California at some point, right? So it would be reasonable for her to think that you lived in California at this point based on these records. Now, that may not be true. It may just be an investment vehicle. You may not have been in California at that time, but it would be a reasonable conclusion for someone to draw that you still lived there, especially when you already had lived there in the past, right? In the relatively recent past, because I think it was 2018 when you said you lived in California, if memory serves correctly. I've reviewed Paulson's declaration submitted in conjunction with the motion to dismiss. Upon review, and my specific review, Ms. Paulson's declaration appears to contain several untrue statements. One statement I believe to be untrue is that defendants have no employees. Okay, well, defendant probably would know for sure whether or not she has employees. So if that statement is false, that would probably be a lie. That's more likely to be a lie because presumably she knows whether or not she has employees, unless she's using the word employees with precision, because maybe they're all contractors or something. I personally recall viewing a video in which Paulson stated her husband was an employee of defendants, and another video where she stated her moderator stated that she had the best employee ever. That was probably using it more informally. But, you can rely on the statement. I mean, she did say it, so it's something you can rely on. She probably didn't mean it literally, but yeah, you can rely on it. She did say it, so it'd be a reasonable basis. But it's probably more reasonable to think that she didn't mean it literally. I have personally witnessed defendants asking their Twitter followers, subscribers, and viewers, some of whom they know to be located in Washington, to donate money for the cost of research and obtaining records to expose me and my wife. Blows a screenshot of whatever. If any of you appreciate my work, please consider a tip. I spend hundreds of hours paying for court records. Yeah, one time she acknowledged that someone lived in Washington, so she actually knew that people lived in Washington. I don't know, man. I do have Fiverr contractors, not all of whom come through with me. Yeah. I have personally witnessed defendant allowing a tweet to be posted on Twitter that I know to belong to defendant, stating defendant were intentionally biased in their stories against me and my wife because of their intense dislike and belief we do not belong in any community. So they're openly acknowledging their bias? That's kind of, if anything, good. Because if you openly acknowledge that you're biased, then people will interpret it differently than if you try to pretend that you're neutral, right? So if you say, this is my bias, I am biased, then people will have a different interpretation. So it's probably good to admit that you're biased if you're biased. So, P.S. I was biased about Toddy because I've done months of research on her story and her husband is a damn fraud. You shouldn't want frauds in the community, in my opinion. So she's openly admitting that she is biased towards them, which is not the same thing as malice to the truth. She doesn't like these people. She's allowed to not like them. She's also allowed to not think that they belong in the community. There are some people in LawTube world who I don't think belong in the community. There's some people in LawTube world I don't particularly like. We're not talking about Emily, by the way, if you're looking for an insinuation. And I'm not going to mention who because that would be impolite at this point. But yeah, if I have bias, it still doesn't mean that I can lie about them, but I'm allowed to say I have bias. I don't like these people. I'm allowed to not like people. It's okay. And then we told the statement under affidavit, and we have some exhibits. So we have some sort of rental agreement. Is this their rental agreement where in the heck is this? Oh, this is their Washington rental agreement. Do we want to read their rental agreement? It's probably pretty standard. So let's see what we got. The tenant is restricted above. So there's standard provisions for what a guest is. Agent acting as a landlord, an 18-month lease, early possession, delayed possession, rent, which we're not going to tell you how much it is. Fair enough. Payment to this address. We got some signatures and initials, other terms. So they got a parking space and a storage unit. They have to provide proof of renter's insurance, which is pretty typical these days. Security deposits, reimbursement for a lease break, custodians, statement of withdrawal, landlord duties to maintain property, tenant duty to maintain possession, alteration, subletting, destruction of property, notice to terminate, service of notice, changes to the lease, rules, disputes. Non-waiver of funds, other waivers. Yeah, it looks like a standard lease, nothing special. You had to get your lease notarized? I mean, I guess that must be some sort of Washington requirement. You had to actually get the lease notarized? I've never gotten a lease notarized in my life. But apparently in Washington, you have to get your lease notarized. Man, that's annoying. But okay, you have to get your lease notarized, I guess, in Washington, if it's a certain length. Standard stuff. mold agreements, mold, agency disclosures, pet addendum, hardwood laminates, and pergo floor care. What is pergo floor? Is it like fake wood or something? I don't know. But apparently there are directions for how to keep that. Condominium HOA. Oh, they have an HOA too? Oh, that's annoying. They have a furnished addendum for the lease. It'd be lease containing items of furniture. So apparently the lease includes furniture. Okay. Some EPA stuff dealing with mold or lead or something. Got some other terms. There's apparently carpet in the master bedroom. Rent to an association, right to enter, HOA lease, sign the document, and a lease extension. So, pretty standard stuff on a lease. Nothing that looks amazingly exciting. All right, so let's move on to... So let's take some questions. We'll do some questions for the chat now that we've read through Toddy and James's thing. We can take some legal questions. They don't have to necessarily be legal questions about what we're reading right now. They can be other legal questions about things we've covered in the past, because I like to be helpful. So, let me know if you have some questions, and I'll try to clarify to the best I can. Is Tatania her real name? Her real name is whatever it was. It was put in the Tatania. Tatania is her legal name. It was in the complaint. Tatania is her legal name. Who wins this case? In your opinion, it's too early to tell who wins. It's too early to tell who wins. But it depends a lot about if KJ's lawyer shows up to the party. Maybe they put it in their answer or whatever, but it's too early to tell who wins. But yeah, if KJ fights it properly, I think KJ has the best odds of winning. Because of the reasons I stated before. Where am I now? I'm still in my apartment. We are trying new backgrounds. So do you like the backgrounds? Yeah. So we're trying different backgrounds, but I'm still in the same place I've been this entire time. Some people said, why don't you try something a little bit different? So I was like, okay, we'll try something different. Do you like it? The background's great? Yeah, I thought so. Wasn't Nick saying Toddy is a vexatious litigant? To the best, well, no. If she was actually declared as a vexatious litigant, I'm sure KJ would have brought it up. But maybe Nick meant it a little bit more casually. But to the best of my knowledge, no. Either informally or otherwise. But no. What is her real name? I mean, it was in the real thing. It was Tatania Westbrook. Tatania is her real name. Tatiana. Tatania. Tatania Westbrook is her real name. Let's see if she gives a longer name at any point in there. She gives a middle name or something. And she doesn't seem to give a middle name. Yeah, but her real name is Tatania. Which is a cool name, I think. What's my favorite book of all time? 1984. It's the one I've read the most. And it's of all time is easy. Would you consider her husband a public figure since he was a few in her videos? His public figure status is a lot harder than hers, but most of the stuff seems to be against her. And also remember, even if you're not in public figure status, you still have to show negligence. So even if James is not a public figure and he has a much better argument than Tatania does, just because he's randomly appeared in a couple videos, I don't think makes a public figure. It doesn't even really make a limited purpose public figure. You probably have to do a little bit more than just appearing in a few videos or a few tweets or something. So it probably requires a little bit more. So let's assume James is not a public figure for the moment, because his argument is a lot better that James is not a public figure. Even if he's not a public figure, to prove defamation, you still have to show negligence. So that's the bare minimum. Not only does it have to be false, you have to show it was negligent. And again, with KJ over here doing all this deep dive research and pulling all his records and doing this invasive, somewhat creepy level of research on both of them, and pulling records and pulling documents and pulling court cases. Like, how do you even get to negligence? How do you even get to negligence when you're doing all that really, really creepy deep dive stuff? So even if he's not a public figure, which I think is quite possible, even if it's not public subject matter, which I think is quite possible, even if he's a purely private figure, you still have to prove negligence. And KJ over here is pulling every document in sight. So how do you even get to negligence, let alone the elevated standard for a public figure? So yeah, I think the defamation looks pretty good for KJ, even if James is not a public figure. So that's what I think. Count of Monte Cristo is also a pretty good book. How much money do I think each side is spending? Lots. We're probably at this point in the lawsuit. We're probably it depends on a whole lot of things. It's hard to say for sure, but I think we might be $10,000. Maybe not that much, but we're heading in that territory rapidly. So we have Toddy's side might be, because she has the response. So Toddy's side might have crossed $10,000. KJ's side at this point, probably less than that, but yeah, we're heading rapidly into some significant numbers. Would be my best guess so far. It takes a lot to be a vexatious litigant. That's right. Yeah, it takes a lot to be labeled a vexatious litigant. Courts are very hesitant to pull that trigger. Couldn't KJ get hit with stalking legally? Probably not. Stalking has some very precise definitions, and it's not clear that she was ever following them around. And even following people around isn't necessarily stalking. There's a legal version of following people around. It's what a private investigator does all the time when they follow you around to figure out if you're cheating or whatever and taking pictures. So just because you're following someone around doesn't even mean that you're stalking. Stalking has some fairly precise definitions, and even pulling records about people is not stalking. Even necessarily following them around is not necessarily stalking. So yeah, stalking has some fairly precise definitions. I mean, I have to look up the relevant law, but it doesn't strike me as stalking, no. Does the name on the notarized document have to be a full legal name? First and last, at least. And she didn't, and her, in the lease, did it give a full name to, in the lease? Yeah, let's see. Like a middle name, but first and last is fine for a notary. Unless the state law requires something more specific, which would be weird, but possible. Well, her middle initial is A, apparently. Whatever A stands for. Yeah, she just signed it Toddy Westbrook. She signed it, well, she actually signed it with TANYA, which is perfectly fine. It's perfectly fine to sign that way, because this is such a technical thing. But well, it's not really that technical actually, and why not for legal education? Yeah, legally, a signature is any mark that you intend to be your signature. So as long as you're intending it when you're doing it to be your signature, it's a signature. And an example of this is the old school person who can't read or write, who just marks X. Make your mark like literally, and they just put X because they can't read and write. So as long as when they are doing it, they're intending it to be a signature, X will be fine. Any mark will be fine as long as you're intending it when you're writing it to be a signature. So this is precisely why an autograph is not a signature, right? So if you get an autograph and it looks suspiciously like a signature, it's not a signature. The reason it's not a signature is because it's not intended to be a signature. It's an autograph. So if you ever want to know the difference between an autograph and a signature, there you go. So will you autograph this? Sure. It's not a signature, even if it looks suspiciously the same as a signature, because it's not intended to be a signature, right? So yeah, there you go. Any mark intended to be a signature will be legally fine. Yeah. So and then Rick says, yeah, that's why I signed at the gas station with the smiley face. Smiley face will work. Any mark intended to be a signature will work. Smiley face will work. X will work. Anything will work. All the things will work. It's all fine. Yeah. Any mark of any variety will be fine. But you can't prove later that X was actually marked by the person. Usually in those examples, it's witnessed as well to solve that problem. But yeah, usually when that happens, it's witnessed as well. And there is theoretically a way to figure out if it was signed by the person. You could always ask them, right? So, assuming that they're going to tell the truth, but, there is ways to prove who signed it. I mean, you could ask, did you sign this? Be like, yes. I'll do it. So, yeah, depending. Or did someone witness it? Who was there? Who saw it? Yeah, there are ways to prove who signed it. And sometimes it's countersigned. So, there you go. So, that is all kinds of fun stuff. So she signed it Tanya, which is perfectly fine. Tanya, I guess. Okay, that's fine. All right, so now we have the Yeah. We have the declaration of Kim Fulmer. Yeah. This reminds me of something I was told as an anecdote one time in law school. I forget who said this or what context it came up in, but it reminded me of something that I learned in law school. So I took one of the classes I took in law school is commercial paper. Commercial paper there's a lot of different kinds of commercial paper, but for the purposes of this example, a check would be commercial paper. It's paper and it's commercial, right? So there are rules for this. There's other kinds of commercial paper beyond that, like, bonds and stock certificates if you're old school. So like old school stock certificates, bond certificates. Then there's other kinds of things beyond that for commercial paper. Anyways, so I think it's in the UCC. It's in the Uniform Commercial Code, as memory serves. I think it's in the UCC that if you have a check and the pay to line is not a person or otherwise determinable, then it's treated as if it's paid to cash. So if it's not made payable to a person, it's treated as paid to cash. Now, you can actually write a check that says paid to cash. You can actually put it in the name, right? So I don't know how many of you have ever written a check, because it's been a while since many of you have written checks. But if you do write a check, when the pay to line, you can just write cash. And then it can be written, and then it can be signed by anybody because it's not signed to a particular person, right? So it can be signed by anybody. And I was told this story of this situation where some law professor somewhere would tell this to the law students, and they actually got a complaint one time from the on-campus bank that everyone used, because everyone uses the bank, and they actually got a complaint from the manager. It's like, could you please stop telling them this, because every time you do, all the students start making checks out to the weirdest things. They make it out to Merry Christmas, they make it out to Happy Birthday, they make it out to all kinds of crap that is just making my life more difficult. Could you please stop telling them that they can make the checks payable to fictional entities that don't really exist, because it's making my life harder. So, funny story, or maybe it's amusing to me, but that's okay. It's my channel. I'm allowed to tell things I find amusing. Yay. So, please stop telling them that this is a thing. Every time you do, they suddenly rush to the bank and make they make really weird checks, and it's making my life difficult. Please stop. All right, so let's read the declaration of Kim Fulner. She's a resident of North Carolina. I was a moderator for the live stream of one of Katie Joy Paulson's YouTube channels from in or around January 2009 to in or around August 2019. All right. So I need to now, and I now need to consider the possibility that one of the people that I have made a moderator on this channel will at some point in the future make a declaration against me. That sounds like fun. So the people I make moderators may turn against me someday. That's good news. All right. When moderators attack, I guess. I became a moderator for Miss Paulson after being a subscriber for about a month. Paulson reached out to me to help moderate her YouTube livestream after I interacted with her as a subscriber. Miss Paulson reached out to me for help moderating her YouTube livestream after part of my duties was to delete negative comments written in the live chat box. Wait for Streamlabs to testify against me. Part of my duties as a moderator, in addition to moderating, I also have my own YouTube channel called Unveiling the Mask. So if you want to go watch this moderator's stuff, apparently she is unveiling the mask. So she has been unveiled. She has been very unveiled because we know exactly who it is. In and around August 2019, I've been falling out with Miss Paulson. She blocked me as a moderator. Miss Paulson had a falling out with somebody? That sounds unlikely. Okay. After I stopped moderating for Miss Paulson, another subscriber and supporter of Miss Paulson's YouTube channel, Without a Crystal Ball, who I know to be Lori Ann Barnhart, threatened multiple individuals, including myself, with violence on Twitter. Well, Twitter is a toxic wasteland, so there's that. Specifically because of my falling out with Miss Paulson, Lori Ann Barnhart made threats against me and threatened to have me murdered by a biker gang. I'm not sure whether or not that's true threats or not. We'd have to get into it, but Twitter is a wasteland, so there's that. Below are actual screenshots I obtained from Twitter that contains the threats of public violence. Lori Ann wrote, I have Facebook friends that are also Twitter friends who can verify who I am and who my family is. So if Steve McRae thinks that he can continue harassing me there, my family will protect me, and they're all over the U.S. Okay. She rides or dies very hard. Please share if you feel inclined to do so. I myself, along with several others, have been targeted by people for defending Katie. I made clear that if they continue to harass me, they will have consequences one way or another. Nah. Michelle is Kim from Unveiling the Mask. I will give anyone my address. Come for me. I have relatives that spend time in prison who are protecting their own and are not afraid to go back to prison. I know who the people are behind this hate campaign. Okay. That's not exactly encouraging. Whether or not that legally qualifies as true threats or not, I'm not going to figure out right now, but I would just recommend not using this kind of language. Your non-lawyer as non-legal advice would recommend you not do this so that we don't have to worry about it. You know. After receiving threats of violence, I personally conducted an investigation and determined that Miss Barnhart is a resident of Washington, and she works for the Office of the Secretary of Transportation for the state of Washington. Okay, that's whatever. I've observed tweets from wherever where I'm informed that by Miss Paulson herself that she operates. In certain tweets, Miss Paulson has interacted with Miss Lori Ann Barnhart and vice versa. In one tweet, Miss Paulson refers to an account I believe belongs to Barnhart as one of her fiercest and loyalist supporters. Apparently so, because if we're not already there, we are well into the road of true threats. So, apparently a very fierce supporter indeed. For the record, I would not like any of my supporters to make death threats against anybody, because that's just bad. Please don't make death threats. That's a bad thing to do. Below are screenshots of additional tweets that show a relationship between Barnhart and Paulson. Katie, please. Oh, so this is Lori Ann. And Katie, please know that you have 74,000 supporters. We love you and your content. Thank you for being the bigger person in this and always standing for the victims. And he's still at it, trying to send a troll army after someone else. This is why victims don't speak out. Mm. Lori Ann is a real person, and you've targeted her, causing her extreme and unwarranted harassment. My attorney sent you a letter yesterday explaining each ethics violation you're violating. With his Twitter spectacle, and further request you cease contact with me. Stop. Fair enough. If you get a letter from someone's attorney telling you to stop contacting them, probably you should stop contacting them, just as an FYI. That would be a clue to maybe not to back off. I've also obtained screenshots of other tweets from Lori Ann Barnhart's Twitter page, where Miss Barnhart publicly displays her support of Paulson on her page and her tweets. Okay, she's a fan. I believe you. In one of the tweets, Miss Barnhart defends Paulson against internet trolls. The stupid, worthless trolls that harassed Katie need a life. That's probably just universally true. The stupid, worthless trolls that harass anybody just need a life. Because, why? Harassing people is bad. These are people. The stupid, worthless trolls that harass Katie probably do need a life. But more to the point, the stupid, worthless trolls that harass anybody need a life. Because people are human beings, and harassing people is bad. Don't harass people. Would you like to be harassed? Probably not. So don't harass others. The silver rule, the silver rule. Don't do to others what you wouldn't want to have done to you. It's a good tip. Follow it. I've also observed that video published on whatever of Miss Paulson's YouTube channel where Miss Paulson is featured. The name of the video I reviewed is Whatever. It can be found at this location. Miss Paulson is seeing this video at some time mark, sharing her computer screen for all her viewers to see. As I'm kind of doing right now. At this time mark, which has a list of people with whom Miss Paulson was communicating privately through Twitter's direct message feature. Miss Barnhart's name and account on the bottom, and information showing Miss Paulson and Miss Barnhart were conversing privately with one another as late as wherever. Okay, so they're friends and they talk to each other sometime. Okay, great. Is this the one where Nate the lawyer gets kind of busted? By implication, it is. My poor friend Nate the lawyer. I'm so sorry. So you got dragged into this too. Because to show that Paulson is talking to Barnhart, we have this thing showing that the private messages between Barnhart and Paulson. And also contained in this, on the second item down, is Nate the lawyer, to show that they're also privately communicating. But okay, whatever. They talk to each other. Okay, that's, fine. Whatever, that's fine. Ryan gives me $5 Canadian. Lol, in before your entire moderator team and maybe Viewpoints makes declarations against you. Fair. Very fair. In addition to Miss Barnhart making threats of violence, I was disturbed to discover in my investigation, Miss Barnhart, that she had criminal acts involving acts of violence filed against her by the state of Washington. That would be troubling. If you're concerned about violence, that she already has some potential record of violence, that would be concerning. Based upon this discovery and prior threats that Miss Barnhart made against me personally and others generally, I have been and continue to be in reasonable fear for me and my family's personal safety, both from Miss Barnhart and Miss Paulson. It's my personal observation that Miss Paulson intentionally instructs, encourages, and condones the harassment and intimidation. Attached herein is a true and correct copy of redacted charging documents against Barnhart obtained from the Superior Court, which are publicly available. And then, fine. There's no. You say it's your observation that they instruct, but you don't actually give any examples, which leaves a little bit to be desired. You could have said, you'd been a little bit more specific on the instruction and encouragement. But yeah, because unless A, this really is her employee, so some sort of respondent superior, which it almost certainly is not. So unless it's really her employee for some sort of respondent superior, or unless this is, unless she actually is encouraging or actually directing it, then Paulson isn't responsible for what Barnhart does in her time. Every YouTube, you can't be responsible for what random people do. If you're directing it, if you're inciting it, maybe. If you're paying them, for sure. But otherwise, And then we got this Superior Court for Snohomish County for Laurie R. and Barnhart, charged with a criminal offense, which doesn't have anything beyond it, in 2012. I'm assuming it was dismissed or otherwise, but at one point she was apparently charged with something. Okay, fine, noted. Interesting, I guess. All right, what else do we got? Take a few questions before we move on to the fourth and final affidavit. You're objecting to a lawyer. You have to object to a judge. Fair enough. She made a video about him. She's all about the drama, just like her. Yeah. I mean, it's okay to be critical. It's okay to criticize others. I think it's okay I think it's even okay to some degree to have drama. Not necessarily what I'm trying to do in my life for the most part, but I think drama's even okay. But, when it gets to threats and death threats and things like that, that's not good. When it gets to harassment, that's not good. That's bad. Probably not do that. $424 people are watching. That's a lot for my channel. Thank you for the 424 people that are currently watching this channel. May I ask so much? Yeah, will Streamlabs bot let me use caps in Super Chat? Probably. Yeah, it looks like it. I should add that source. Hold on. Browser. Streamlabs. Yeah. Add existing. Add. Make visible. And then that didn't work. Add existing. Streamlabs. Select. Oh, there it is. Sorry, it went off screen, but I had to find it. Then I made it hidden. There you go. Put that like that. Anyways, so will the Streamlabs bot let you use chaps in Super Chat? Yes, apparently it will. Oh, as I was going to say, for the 425 of you who are currently watching, may I be so bold as to please ask for you to subscribe if you've not already done so. I'm really trying to make this channel grow and really trying to produce content. And one of the reasons I'm making this video in the first place is because so many of you were here last time, and the last video I made on Tea Hour was incredibly well received. And so, I'm trying to respond to things that people like. So please subscribe. It helps the channel grow. I'm celebrating hitting 19,000 today, and if we could somehow squeeze out 20,000 before the end of the year, that'd be cool. So if you hit subscribe, if every one of you hit subscribe, it would probably help a lot towards that goal. So if you hit subscribe, I'd really, really appreciate it. Please help the channel grow. It makes me happy inside, and it encourages me to keep going. Does the declaration play to jurisdiction? Technically, Lolly is a contact in Washington KJ claimed not to have. Well, no, I don't think so. Because I don't think so, but it's an argument. Yeah, it'll be interesting to see if when Emily really gets into like discussing the jurisdictional issue. Maybe we'll discuss that on stream, if not before, because that would be interesting to see what she thinks on the jurisdiction and the jurisdiction probabilities. But just because you have a moderator that to be in Washington, I don't know. That doesn't sound like enough to me. What did you miss? You missed 3 declarations. We have one more, and then we have a motion to oppose entry of judicial notice of things, which we'll get to in a second. Kentucky Girl says, congrats. Thank you. I appreciate it. Thanks on 19,000. Thank you very much. I really, really appreciate it. Yeah. We were stuck at 18.5 for a little bit there, and then we gained a lot in the last couple of days. Last 4 or 5 days, we've gained a lot. So really, really appreciate it. Thank you. Did I see Nate the lawyer pointed out in the lawsuit? I did. I mentioned it. I said poor Nate. I did make a point of mentioning it when he said, poor Nate. Got hit by proxy. Yeah, hit the like button and all that, right? Subscribe to you earlier today. Thank you. Watching from Florida. Enjoy your sense of humor. Thank you. I am fluent in sarcasm, having spent 30 years in public safety. Fair enough. I'm subscribed and a member. Congratulations on 19,000. Thank you. I really, really appreciate it. And welcome Kalam 911. How does one assume that KJ knew Lori was from Washington? Yeah, that's a fair point, too. How would you know that she assumed that? It may be that she worked for the Washington Department of Public Safety, but you wouldn't necessarily expect her to know that. You know, what she does during their day job is kind of neither here nor there, you know? You missed it, you're multitasking, that's okay. We're here for you. All right, cool. So I think we're all caught up on law. We're all caught up on law questions as much as we can be. I often wonder if people get the dry humor. I hope so. I hope the deadpan delivery comes through when I try to emphasize the deadpan delivery so that people will get the joke. But you do always have to wonder when you're really deadpanning it if people will get the joke. But it's kind of humor I like. What area of law do I practice? I do patent law, which is not this, but that's one of the things I like on this channel is because it gives me the opportunity to talk about everything except my day job. You know, I find my day job a little bit tedious at this point because I've been doing it for 13 years. I'm ready to move on to other things. But yeah, patent law. My background is computer science. And then I went and got a law degree. So I deal with computer-related inventions, databases and search engines and stuff like that. So, not the sexiest topic in the world, but, you know, that's okay. I'm a sexy man, so I can make everything sexy. Emily did do a video on it last night. I did see her video on it last night. I did see it. It seemed to me, and someone will correct me if I'm wrong, but it seemed to me that her was more of a tea dish rather than really getting into the weeds of the jurisdiction issue. But I did see that she did a video on it, and I watched it, and I thought it was very good. She has a very warm and engaging presentation style, but it didn't appear to me that she was really getting into the weeds of the jurisdiction issue. It seemed a little bit more tea-ish, which is perfectly fine, but maybe other people had a different impression of it. But I didn't really see I didn't really see in that video a detailed substantive analysis of the personal jurisdiction issues, or at least not to the level of depth that I was hoping for. I was hoping for more if it was there. So we'll go with that. All right, so let us do the last thing. No, not the last thing. We have one more declaration. It's a short one from Hope Walker. Hope Walker says she's a resident of Washington. I was a supporter of Tati's from 2017 to 2019. I'd watch on a regular basis the monetized videos to which I was a subscriber. So we're saying that we're proving that we're getting revenue from Washington. How did Tati's lawyer find these people? That's a good question. Did she put out like a call somewhere? How did she find these people? Their lawyer find these people? That's a good question. I'm aware Tati has some ownership connections with Halo Beauty. I purchase vitamins and send them to my Washington residents. I personally found the vitamins to be effective. I was preparing to purchase a subscription for $40 a month. I started to watch videos on YouTube on a channel called Without a Crystal Ball, which features a person that goes by the name of Katie Joy Paulson. I eventually became a subscriber of that channel. In addition to watching Paulson's video on the YouTube channel Without a Crystal Ball, I also follow Paulson on her Twitter accounts. This is about to be some really petty tea right now, isn't it? This is about to be some really petty tea. First I watched Tati, and I loved everything she did. And then I watched Without a Crystal Ball. And because of Without a Crystal Ball's lies, I swore off. I took a blood oath against Tati. I took a blood oath against Tati because of the lies. And I have deprived her of her rightful business that she was, only because of the lies, the horrible lies. This is about to become some real sharp tea here, isn't it? In declaration form. It's like I feel like I know where this is going already. Yeah. As a subscriber and follower, I broadcasted in the state of Washington. I personally saw the social media postings and video regularly attacking Westbrook, her husband, and their company. The two videos in particular stood out to me are Sephora arrived at my house, and I'll answer questions too, and the past James and Tati Westbrook don't want you to know. Specifically, prior to viewing the content, I thought Tati and James Westbrook were good people trying to do good things in the world. I had a positive reputation of them before. Wow. How do we find these people? That's what I want to know. And that they created a great product through Halo that I was able to afford and I was happy to support in the state of Washington. Oh, man. Yeah, this is a lot. However, my perception of Tati and James Westbrook changed drastically when I saw that Miss Paulson claimed in the above-mentioned videos and on her Twitter account that she had done extensive research on James Westbrook and thereafter portrayed him as having personally taken out reverse mortgages on his mother's house to steal all of her equity in her own property and having removed his mother's oxygen in order to cause her untimely death so he could steal the assets. Based on Miss Paulson's statements and social media posts, I believe Miss Paulson's statements and representations as to her portrayal of James Westbrook and by through extension through marriage of Toddy to be true. I was such a fan, and I was deceived. I was deceived by the honeyed word as KJ. I was a loyal purchaser of these products, and I would be if not for the lies. The extensive lies. This is the best tea ever, man. This is so tea. Wow. Miss Paulson's representations of James Westbrook and extension Tati with regards to the mother really affected me and caused me to develop negative feelings towards James Westbrook, Tati, and Halo, which then caused me to stop purchasing Halo vitamins. Wow. Specifically, I took care of my mother for many years before she passed away, and I know how difficult it is to make an end-of-life and estate-related decisions. However, by the way, Miss Paulson described the behavior of Mr. Westbrook, and by extension Tati, was so appalling. I was completely turned off to Halo, and I did not want to support a business owned by a married couple I was led to believe stole from a parent and caused the untimely death of a parent for inheritance purposes. As a direct result, this was, yeah. You know, I don't know that there's a better way to do this. But like, if a lawyer is going to put words in a client's mouth, and I don't begrudge it, because like every declaration and deposition and sworn affidavit is written by a lawyer, because of course it is. Because you know, especially when you're making things under oath, you want them to be as good as they can be, right? You would never ever let a client write one of these things ever, because you want it to be as accurate as possible. But I feel like maybe there was a way to do this that was a little bit less obvious that it was being done by a lawyer. It's like, if you're going to put words in their mouth, which every lawyer will do, maybe don't make it seem like your hand is so far up them that you're talking through their hand as a puppet. Maybe make it just a touch less obvious, a touch or two less clear that they are but a ventriloquist dummy for your words. Maybe don't make it quite so unbelievably obvious. This is a lot. Yeah. As a direct result of these representations, I decided to go elsewhere for my vitamins. I unsubscribed from Toddy's monetized videos, and I stopped watching the videos. I also note herein that I'm aware of various YouTube controversies that have occurred, involving Toddy, including but not limited to Dramageddon, Carmageddon, and Dramageddon 2.0. However, throughout these controversies, I was never swayed to stop my support of Halo or Toddy's monetized YouTube channels and videos. So it wasn't any of those things that got me to stop buying the vitamins. It was KJ's mean, horrible words. Specifically that. Wow. It was the specific allegations and representations that Miss Paulson made in order to portray Mr. Westbrook as a person that obtained so many reverse mortgages on the mother's property that he stole all the equity from their home, and he ultimately caused the untimely death by personally removing his mother's oxygen so he could steal the assets that exclusively impacted my... Wow. It exclusively impacted my decision to stop buying products from Halo. Wow. It's like, it couldn't... I also note that it's not signed, the one that's on the record. It's not signed. That's good news. So whichever lawyer submitted the non-signed copy. Good work. I'm looking right at it, man. I'm not seeing a signature. You submitted the not signed version. Okay, so that's a fail. Fail is I failed to actually sign it, so this doesn't technically exist because it wasn't signed, so it doesn't exist. And number two, maybe make it a little less obvious. It's my sole reason that drove me to this reprehensible decision to stop buying the vitamins and stop watching it. Nothing else, only this. Maybe make it a little less thick, because it's like, and also get them to sign it and submit the signed copy. That'd be helpful. Okay, great. Yeah, we've scrolled all the way down. There is no more down. There is additional pages signed. No, there's not. No, there's not. We're on page 404. There's no signature. No, we have scrolled through the entire thing. We are on page 404. See, it says right there at the top, page 404. All right, we're on the last page, and there is no signature. There is not a signature on the next page. There is no next page. We have reached the end. This is the end. My lonely friend, the end. All right, great. So now we have the opposition for judicial notice. So we'll spend a little time. Yeah, we'll spend. Yeah, it's a mistake. It's just a mistake. They'll fix it, but still, it's not a great look. They'll fix it. They'll fix it. Anyways, okay, so let's discuss a little bit what judicial notice is. So judicial notice is a way to save time. It's a way to enter facts on the record without having someone to testify about them. So the way that judicial notice is done is it's supposed to be something that's uncontroverted, and uncontrovertible. It's supposed to be something that is so plain and so clearly true that no one could dispute it, except maybe insane people. But we don't have to listen to the insane people. So if you asked a court to take judicial notice that the earth was round, they would take judicial notice the earth is round. Despite the insane people who seem to insist it's not. The court's going to be like, yeah, it's round. It always has been round. Sorry, it's just round. So that's the kind of, we're taking notice of things that are so uncontrovertibly true that only a cray-cray would say that they're not true. So KJ apparently asked for judicial notice of stuff. So they want the court to take notice of things that are completely uncontroversial. Okay. So they're saying things are controversial, presumably. So let's read that and see what they got. The one that Emily downloaded has a signature. I mean, I downloaded it straight from Pacer, man, so I don't know. But maybe I don't know. Well, we'll ask Emily where she got her copy, but anyways, it's not on mine. All right, so let's see what we got. Defendants have filed a separate request for judicial notice in addition to their motion to dismiss in an attempt to rewrite the facts of this case and insert characters who have nothing to do with the allegations defaming the plaintiffs. Okay, the vast majority of the facts portion of the motion rely upon citations to defendant's appendix contained within defendant's request. Okay, fair enough. As explained below, defendant's appendix is comprised of two sections. Appendix A, which is a Los Angeles Superior Court complaint, and Appendix B, a series of unnamed links to websites and videos, none of which have anything to do with causes of action. Well, yeah, okay. So, I mean, Appendix A, you'd take notice of, because if it's a judicial thing, and if it's an accurate thing, you take notice of a judicial record. That'd be fair. The unnamed links, websites, and videos, you could take notice. I mean, you wouldn't take notice of them because you could always have fights over authenticity or something if you really want to. So, yeah, that might not be so much. Well, apparently Emily has a secret copy or something, so I don't know. Defendants oppose the request for judicial notice as defendants failed to meet their burden of establishing how any of the documents requests satisfy either of the legal standards set forth in the federal rules. Defendants' request for judicial notice of news articles is improper under federal rules, and defendants' request of judicial notice for YouTube videos is improper. Okay, fine. The federal rules of evidence state a court may take judicial notice of an adjudicative fact that is not subject to reasonable dispute because it is generally known within the trial court's territorial jurisdiction, or it can be accurately and readily determined from sources whose accuracy cannot be questioned. Things that are undisputable facts. Defendant's request for judicial notice has failed to meet this burden of establishing which element under the rules. That's fair. Is defendant burdened to meet the requirement as defendants who are requesting the court take notice? It's unclear whether the defendants are requesting the court take judicial notice of adjudicative facts under the rules or pursuant to the rules. Pretty fair. Their request could have been better drafted. Nowhere in the request do they submit citation to any rule which defendants are requesting judicial notice. Nor do defendants' requests state that the rule is pursuant to the rule. The failure to meet this burden is fatal. Probably true. Try to law better would be try to law better is a fair comment. Try to law better is a fair comment. Defendants improperly seek judicial notice of the context of Appendix A, which is a Superior Court complaint, and Appendix B, which states they're YouTube, but are actually news articles and unauthenticated videos. Fair enough. Lack of authentication. Fair enough. Defendants' request for judicial notice of Appendix A is improper, as defendants claim they're requesting judicial notice of the document solely for the purpose of recognizing the existence, if seeking to have the court recognize the contents and even misstate the contents of the document. Okay. Defendants first request the court take judicial notice of Appendix A, which is a complaint on file in some other case. Defendants claim the request is solely for the purpose of recognizing the fact of the pleading and its contents. Defendants state they're not asking the court to take judicial notice of anything, of the truth of anything. Okay, fair enough. They're not asking judicial notice for the truth. We're just asking, this is a thing that exists, and here are the contents of the thing. Please take notice that it exists. If it's an accurate filing, I mean, at least if I were a judge theoretically, because I'm not really a judge, but if I were, I'd be inclined to grant judicial notice for that. It's a document, it exists, noted. As long as it's accurate, it's an official record, so it's self-authenticating. It's fine. Defendants rely on statements contained in the complaint as true in several portions of their motions. Okay, well, that's a separate problem, as far as I'm concerned. For example, in page 2 of the motion regarding the sworn complaint, page 7 of the motion stating what was followed was widespread media coverage of the claims, and especially for fraud evidence and the evidence of Westbrook's cynical contempt for customer and fans. Well, it is evidence. It is evidence. The quality of that evidence has yet to be determined, but it is evidence in the literal sense of the word. Contrary to the statement for judicial notice, defendants also rely on the following statements as basis for jurisdiction argument in their motion. Their business partner, Clark Swanson, under penalty of perjury in his verified claim, stated through yeah, so that's fine. And that goes to, again, not necessarily the truth of it, but their ability to rely on it. So it doesn't have to be true. It doesn't have to be true, and they're not necessarily arguing it is true. It seems to me, right? So I want you to take judicial notice of this document, and it exists. I want you to take notice of the contents of this document. I don't want you to say that anything in here is true. I just want you to take notice it exists. Now, as long as it's an authentic copy, as long as they're not saying that this is not a true copy. So if they're saying it's not a true copy, then we'll have a fight about it. But if it's a true copy, if I were a court, I'm inclined to say yes. It's like, yes, I will grant your motion for judicial notice that this thing exists and the contents of it, but not the truth of it, right? Fine. All right, great. So now you, as KJ, presumably then want to turn around and say, okay, so this motion made this claim, right? I then relied on that in forming my statements, right? I knew about it at the time. So my argument would be, I knew about it at the time. Based on that is why I said certain things. So I'm not saying it's true. I'm saying that's why I made certain statements. So it's even non-hearsay. It's not even hearsay at that point. Because, this is very, very technical. But we'll try to make sure this is clear. I'm not offering it for its truth. I'm offering it to show why I did certain things or why I made certain statements, right? So I'll give an example, or I'll try to create an example where this makes sense, all right? I'll try to create an example between the difference between the truth, the underlying truth of the statement, and the action based on the statement, and why one is hearsay and one is not, in a technical sense. Because to be hearsay, it has to be an out of court statement offered for the truth of the statement. That's the critical part. It has to be offered for its truth, not for some other reason. All right. So let's say, what would be a good example this is true? I'm trying to create a hypothetical in my mind where this will be clear enough. So give me a second to create the hypothetical. Okay. I come to meet you. I come to meet you at a cafe or something. And I have with me an umbrella. And you ask me, why do you have an umbrella? I don't know why you're asking this question, but you are. You're asking, why do you have an umbrella? And I say, well, it's because the weatherman told me it was raining. So in that situation, I'm not saying it was in fact raining. The statement is on its literal terms. I'm not even telling you whether or not it rained. I'm not telling you whether or not it rained in that statement, right? So you ask me, why do you have an umbrella? I'm not saying because it was raining. I'm saying I have the umbrella because the weatherman told me it was raining. So I'm not even right now saying whether or not it in fact rained or not. I'm not even saying whether or not it's true or not, right? I'm not offering that statement for its truth, that it was in fact raining. I'm offering that statement to show you the reason I did a particular thing. So why did you bring the umbrella? Because the weatherman told me it's raining. Whether or not that statement was true or not is irrelevant, right? I brought the umbrella because they told me it was raining, right? So whether it was true or not is completely irrelevant. That is why I did the thing. So that is the situation that seems to be going on here. So what KJ seems to be saying, and what they seem to be fighting over, is the statement in this lawsuit says Toddy is a resident of California. Okay, that's the statement basically reduced down. The statement reduced down, made simple, not literally, but to make it clear, reduced down. The statement in this lawsuit is saying Tati is a resident of California. Great. KJ says, I want you to take notice that this lawsuit exists. I want you to take notice that it says this, but not that it's true. Fine. No problem. Judicial notice. Granted. No problem. Now, she might want to turn around and say, I saw this lawsuit. I saw it said that Tati was a resident of California. Because it said that, I made these statements. I drew these conclusions. I did X, Y, Z. So I'm not arguing that it was true. Its truth is irrelevant. I'm arguing why I did a particular thing, why I took a particular action, why I said a particular thing. I am not offering it for its truth. I'm offering it to show why particular things happen. So hopefully that distinction makes sense. So it's not hearsay because I'm not arguing, the way that KJ would be arguing this is not for its truth. I'm not arguing it's true. I'm arguing I saw it, I took notice of it, and that's why I did a particular thing. Those are different things. And hopefully the it's raining example made that sense. So hopefully all that made sense. Because I was trying to think of a way to explain it, and the example, why did you bring an umbrella? Because the weatherman told me it's raining. I'm not claiming it's true. I'm not claiming the underlying statement is true. That the fact it was raining. I'm not arguing that is true. So I'm not making any claim as to whether or not it was or was not raining. I'm not making any claim. And also, whether it was or was not true that it's raining is irrelevant. It's irrelevant. The reason I brought the umbrella is because he told me it was raining. That's why I did it. So hopefully some of that makes sense. Because this is a thing that you have to really, really think about what is hearsay and what is not hearsay. You know? I'm not offering it. I'm not saying it's true. I'm saying this is why I did a thing. So hopefully that makes sense. Yeah. So hopefully that makes sense. So Toddy over here is saying defendants are relying on the statement as truth It's not clear that they are. It's not clear they're relying on as truth. So I don't think that's necessarily right. And they say, what follows was widespread media coverage of the claims, including the following allegations and evidence of the cynical attempt. It is evidence. That's something. So it doesn't look like I'm trying to say it's true. I'm trying to say this is why I said certain things. This is what I relied on. This is why I thought they were residents of California. I thought they were residents of California because this guy said they were residents of California. That was the basis for me drawing that conclusion. Were they residents of California or not? It doesn't matter. It doesn't matter because I'm not arguing that they were in fact residents. I'm telling you why I did a particular thing, why I took particular action. Contrary to the statements in their request, defendants also rely on the following statements as a basis for jurisdictional argument. Their business partner, Clark Swanson, under penalty of perjury in the verified complaint, stated the Westbrooks were citizens of California from 2006 through the filing of his complaint in October 2018. Right? So, it seems to me, KJ is not arguing that statement is in fact true. She's arguing that she believed it to be true, and based on that, she took particular actions, made particular statements, and blah, 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 whatever. So the underlying truth is irrelevant. It's the reason that she took did particular things, said particular things, took particular actions, wrote particular things. This was why I did it. Because of this. Whether it's true or not, don't know, but that's the basis of what I did it. Right? Not to put too fine a point on it, but I don't know whether or not anything in any of these documents we've read is actually in fact true. Because how would I possibly know? I don't know. I'm not a witness. I have no clue whether or not anything in any of these documents we've been reading is in fact true. I have no freaking clue. But because it exists, I'm making this video. So I have no clue whether or not it's true. I don't know. I'm not even telling you whether or not it is true because I have no clue whether it's true. I'm not a witness. I have no basis to know whether or not it's true. I can make assessments as to a relative likelihood of being true. I can say that this rings true or it appears true or seems true or something like that. But ultimately, is it true? I don't know. I wasn't there. So I have no idea if it's true or not, but because it exists, I made these videos. I'm not even making a claim as to their truth. I'm making a claim as to why I'm doing particular things. Because they exist, I'm making these videos. Because they exist, I'm making this analysis. You know? So that's the difference. I'm not offering it for its truth. I have no idea if it's true. Neither does anyone else. None of you have any clue as to whether it's true or not, because none of you are these people. You know, none of you have any clue as to whether it's true. How could you possibly have any clue as to whether it's true? You know, you can assess the relative probability that it's true. You could take notice of the character of the people. You could take notice of the degree to which they've been truthful or not in situations in their life as to their relative veracity or the degree of credulity that you should apply. So you could say, well, I'm more inclined to believe it's true, less inclined to believe it's true, because here's 18,000 other times they lied. But strictly speaking, just because they lied 18,000 other times doesn't mean they're lying this time, right? I mean, it's likely, it's probable, it's but strictly speaking, I lied 3,000 times in the past doesn't mean I'm lying now, And just because I told the truth 3,000 times in the past doesn't mean I'm telling the truth now. Strictly speaking, right? I mean, none of you have any clue as to whether it's true. How could you? You weren't there. So KJ doesn't seem to be saying it's true. She seems to be saying this is why I did things, which is a perfectly good argument. If I was in KJ's position, would I eat yourself off the internet to make sure extra things didn't end up in depositions? I'd think about it for sure. I mean, a lawyer would be cautious. So a lawyer would tend to advise not to talk about things, but you might give more specialized advice than that. So, all right. So anyways, the motion also relies on statements purportedly made in the complaint, but actually are nowhere in the complaint. For instance, defendant states just days after the defendant broke the story of the $5 million suit against Westbrook, the Westbrook seeking to deflect attention from this $5 million claim. However, nowhere does it state this is a $5 million claim. Well, what did it actually say? Doesn't it say like at least $5 million or some other language that's like that? So it's like maybe it's being a little bit imprecise, but yeah. Plaintiffs do not dispute the existence of the claim. Plaintiffs do dispute the veracity of the statements. As such, the statements are not being determined accurately and readily from sources whose accuracy cannot be readily questioned. The truth of the contents are not proper subject matter. The truth is not subject matter. That's correct. The truth is not a proper subject matter. That's correct. But that isn't what KJ asked for. KJ asks very specifically not to take notice of the truth of it. Taking notice of the truth of it would be wrong. But taking notice that it exists, taking notice of what it says, sure, it exists. This is what it says. I mean, it's a legal document. You know, it's been filed in a court somewhere. It is beyond any possible dispute. The only question is to whether or not it's accurate. You know, so that has been forged or something. But short of that, sure, you can have judicial notice that it exists. You can have judicial notice of its contents, but not judicial notice of its truth. So you can't argue the court took notice that it's true, but that it exists and that's what it says. Sure, you can have judicial notice of that. No problem. And then KJ turns around and says, well, I'm not arguing it's true. I'm arguing actually it doesn't matter whether it's true or not. And KJ would be right. KJ would be right. It doesn't matter whether it's true or not. She'd be right. From her perspective, it wouldn't matter. The Swanson complaint states there are penalty of perjury that Mr. and Mr. Westbrook are residents of California. Defendants relied upon the statement as a basis for a jurisdictional argument. Yeah, you know, it's something. I mean, that's not going to fly because I'm not going to take notice that it's true, but that would be a basis for me arguing it at least. But like, yeah, here's one guy who said it was true. So, but yeah, I mean, I'm not going to agree to the truth. This statement is knowingly false. Counsel knew it to be false at the time it was made. And thus, which counsel are you referring to now? This is a bit ambiguous. Which counsel do you mean? Unless it's the same attorneys. Is it the same attorney? But it's not clear. It's not clear which counsel you mean. It says the Swanson complaint states under penalty of perjury that Mr. and Mrs. Westbrook are residents of California. Defendants then rely upon the statement as a basis for jurisdictional motion. And then it says this statement is knowingly false. Counsel knew it to be false at the time it was made. Which counsel do you mean? Do you mean KJ's counsel or do you mean Swanson's counsel? It's ambiguous which one do you mean. Who made knowingly false statements? Swanson's lawyer or KJ's lawyer? Is KJ making knowingly false statements now? Or did Swanson make knowingly false statements and their attorneys make knowingly false statements? Which attorneys are we referring to in this sentence? This is ambiguous. Which it means. It says this statement is false. Counsel knew it to be false. Which counsel? It's ambiguous. Yeah, it's ambiguous. Counsel knew it to be false at the time it was made and thus proffered such argument in bad faith and in breach of his duty of candor as an officer of the court. Counsel then attempted to support the statement with his own findings for Mr. Westbrook's social media in order to somehow evidence that Mr. Westbrook lives in California. She does not, but fails to disclose that Mr. Westbrook's social media account had published pictures of Miss Westbrook at the exact same time in Seattle. A failure to disclose these earlier postings in light of the arguments made by defendants indicates Mr. Brown's presentation and use of the evidence is being proffered for the purpose of misleading the court. I don't like the way this is written. Because it's written in a way that's ambiguous. It should say something like present counsel or current counsel. It's ambiguous the way it's written. And I understand that some people are like trying to read later sentences in a particular way, but I don't like the way this is written because it's written ambiguously. So it should really say present counsel or current counsel or maybe even by name, but it's like, which one do we mean? Counsel knew it to be false at the time it was made. How would counsel know it was false? How would counsel know that? How would KJ's lawyer know it was false? what Swanson wrote in his complaint. How would KJ... That's not clear. How possibly could KJ's lawyer know that what Swanson put in their complaint was in fact false? How would they know that? They're not Swanson's lawyer, so they would have no privileged information. So how would they know that Swanson lied and know it to be false? How would counsel know that? Something is weird here. Counsel knew it to be false and proffered the argument in bad faith and breach of duty. How did counsel know that? It doesn't say. Counsel then attempted to support this statement with his own findings from Miss Westbrook's social media in order to somehow evidence that Miss Westbrook lives in California, which is a valid thing to argue. If social media makes it appear that you live in California, for example, by taking photos or things that are tagged in California or whatever, I mean, that would be a reasonable basis to think you live in California. Here's some Instagram posts or here's some Twitter posts that were made in LA, or at least look like they do. So that would be a reasonable basis to think it's true. How would the counsel know that was false? He failed to disclose Miss Westbrook's social media account has published pictures of Miss Westbrook at the exact same Seattle location. In the exact same location, as early as February 2019, that he contests does not exist prior to December of 2019. No, I don't think that's what he's contesting. He's contesting that she didn't live there, but she might have taken photos of a location in 2019 without necessarily living there. I mean, even if it's of the apartment, she didn't necessarily... I mean, is it possible that a person could take a photograph of an apartment in February of 2019 that they don't yet live at? Yeah, I mean, if they're on a tour or something, I mean, yeah, sure. So, like, how would counsel know this? Because of KJ's involvement with Swanson, that means KJ would know it's false, not that counsel would know it's false. So KJ might know it's false, but how would her attorney know it's false? Are we presuming that KJ told the attorney? How do we know that? We can't possibly know what KJ told the attorney because it's privileged. On what possible basis are we thinking that counsel knew this? This is very odd. Cody Sams, if I swing by for a visit and take a photo, I basically live there? No. I'm just trying to understand. No, it doesn't. No, it means no. But if you have photos of you in Seattle in February 2019, does it mean that you live there? No, not necessarily. Even if it's of an apartment, does it mean that you live there? No, not necessarily. Maybe you're visiting. Maybe you're on a tour. I don't know. Maybe it's faked. I don't know. But yeah, you have photos of a location in February 2019. Does that mean that I know that you lived there in February 2019? Hell no. I know that you have photos that appear to be of there in February 2019. That's about the extent of my information. KJ put in a video with their business address on their business filings. That doesn't... It's an address. It doesn't say what you need to say. This seems very odd. This seems very odd. We're throwing counsel under the bus when I don't think we should or even can. This seems very, very odd to throw counsel under the bus here. The failure to disclose these early postings in light of the argument being made by defendants indicates Brown's presentation and use of the arguments being declared is proper for the purpose of misleading the court about fact defendants know to be false. I don't like this at all. This is coming to very extreme conclusions. And this is making aspersions against counsel when it's completely unnecessary. And I mean, there's no basis to think that counsel knows that their argument is false. There's evidence to conclude it's true, including this affidavit over there. I mean, that's some basis to think it could be true. I mean, it's not necessarily true, but it's some guy under penalty of perjury is willing to say it's true. So that's some basis to think it might be true. I mean, it doesn't mean it is true, but at least there's a reasonable basis to think it's true. I mean, are you more likely to think that something said under penalty of perjury is true? Probably. So, if the attorney saw this statement under penalty of perjury and said, well, I have reason to think that might be true, because you do, because it's sworn under penalty of perjury. It's like that you know it to be false. This argument seems completely off. Why are we throwing aspersions at opposing counsel? This seems, yeah, I don't like this at all. This is very, very odd. And even if KJ had told him, he still doesn't know it to be false because he has contra information. So even if KJ said to her attorney, like, I didn't think that they lived in, I didn't think that, even if she said that, he still has a basis to think it could be true because he has a sworn affidavit from some other guy. So even if KJ actually told her own lawyer, I didn't think they lived in California, even if she said that, the lawyer would still be reasonable to think that KJ is wrong and the other guy is right because that's also being under sworn affidavit. It's a reasonable basis to think it's true. I mean, you think a lawyer automatically believes everything their client says is true? You know, what insane world do you think that is? You know, just because the client says it doesn't necessarily mean it's true either. You know, so it's like, well, that's interesting and all, KJ, but you know, I have this other thing over here which suggests the opposite. So, and that would be helpful for me. So I'm going to go argue that. And then you want to say it's knowingly false? Even if you could somehow pierce the attorney-client privilege to prove that KJ actually told me that she didn't think it was true, well, I do have this other document from this other guy that says it's true. So I'm going to go rely on that other than my own client because I'm here to make the best position for my client. So even though my client doesn't think it's true, I'm going to advocate for the best position of my client, and it would be helpful for me if it was true. So even though my client doesn't think it's true, this guy thinks it's true, and I have a reasonable basis to think it's true because it's in a sworn affidavit. So I'm going to go rely on that instead of what my client told me, because that would be helpful to my client. So even if you could prove somehow they told the attorney, you still wouldn't get to knowingly false. You know? So, yeah. I mean, you guys in chat are generally, it seems to be, of the opinion, and the chat will correct me if I'm wrong, but it seems to me that the chat is generally of the collective opinion that KJ may not be the nicest person or potentially the most truthful person at all times. Now, that seems to be the impression I'm getting. The chat is of the generalized opinion that KJ does not appear to be the nicest person and or may occasionally not be always telling the truth. So if the chat is collectively of that opinion, do you think that maybe her own lawyer might also be of that opinion? And if the lawyer's of that own opinion, maybe even if KJ told him that, maybe he's also thinking the same thing chat is collectively thinking. Maybe this is not a nice person, maybe not necessarily the most accurate, truthful person at all times. So maybe even though my own client says it, maybe it's not the word of God. And maybe I could also rely on this other thing from this other person of whom I do not have doubts. So the very reason the chat seems to be distrustful of KJ, right? The very reason the chat seems to be collectively distrustful of KJ, maybe her own lawyer has also come to that conclusion. And like, maybe I'll go rely on this statement from this guy named Swanson. That seems reliable. Let me go do that instead. You know, which would be in service of the client. My job as the attorney is to zealously represent my client. So it's like, well, I don't necessarily believe you, but I'm going to help you achieve your own ends because I can. And in order to achieve that, I'm going to go rely on this statement over here, which I find to be reliable, specifically because I don't find you reliable. Maybe the lawyer did that. Maybe the lawyer didn't believe KJ, as you guys don't seem to believe KJ, and said, I'm going to go rely on this thing from Swanson instead. Maybe that's the thing that happened. Who knows? You know? And also, this is a personal pet peeve of mine. But I take exception to throwing the other attorney under the bus unless it is really needed, because my client hates his client. My client hates his client. That in absolutely no way requires me to hate the other attorney. Whatever problems my client has with their client, or their client has with my client, whatever problems that may be, that does not require me to have any problems with the other side's attorney. The attorney is not the client. I am under absolutely no obligation in any sense to not like them personally or to go after them personally. So I really dislike when an attorney goes after another attorney unless there's like really good reasons to go after the attorney, because the attorney is a dipshit or something, or not being a good attorney, or is really actively lying, or really being a really bad guy. So unless the attorney is really, beyond the pale, just for a little thing, I'm the client is not the attorney. I'm not required to hate the attorney. I could theoretically even have beers with the other counsel. Maybe we'll have beers together and sing sailor songs or something. I don't know. Whatever. I could even be friends with him. That could be a possibility. I'm not required to hate him. I'm required to help you get your case done. So I do take a bit of exception when one attorney throws another attorney under the bus when it seems completely unnecessary and unwarranted. Because why are you starting a fight with me? I'm not the client. Now you're starting a fight with me. Why am I being dragged into this? This is not my fight. This is their fight. I'm just here to supervise an adult hour. Why am I being dragged into this like I'm a party? There's no reason to bring me into this fight, man. You know what I'm saying? I'm just the attorney. I'm not the client. You're not suing me. You're suing them. Please stop, okay. Defendants knew Ms. Swanson's statements regarding California residents' default well before the filing of the complaint. How? Yet nonetheless rely on the false statement in their motion. How did they know it to be false? Because of some Instagram posts that were taken in Washington? Yeah, I mean, Toddy herself in her own argument has made a point of pointing out that sometimes when it says that she's in a particular location, it's not true, because she's concerned about her safety and her whereabouts, right? She made a point of this. Toddy made a point of this. Just because it says it was in this location at this time doesn't mean it was that location or that time. Sometimes I fudge it because I'm concerned about my own safety. So you want to say Toddy apparently fudges her own stuff, but defendant knew it to be false because of photos that Toddy took in Seattle? That's why defendants knew it to be false. Toddy herself says basically that she lies in these things because she's concerned about her safety. She's concerned about her privacy. Sometimes it says that she's posting it from one location when she's really in another location. Sometimes it says one time when it's really a different time. Toddy herself says these things aren't reliable. And now you want to say the defendants knew for a fact that what they were saying was false because they knew of photographs that Toddy took or whatever bullshit Toddy posted? How could I rely on that? You yourself say it's unreliable. Your argument is that it's unreliable. Toddy's argument is that it's unreliable. Toddy herself says that these posts that say that it's a particular location or a particular time sometimes is fake. Sometimes I'm not even the one posting it. Sometimes it's my manager. Sometimes it's one of my other people that helps me. It's not even me that's doing it. And sometimes it says it's this location when it's not. And sometimes it says it's this time when it's not. Sometimes it's lying to you. And then she wants to turn right around and say KJ and the lawyer are knowingly lying, presumably because they're aware of these posts and these Instagrams and these tweets and these videos, which Toddy herself says are not reliable. And it's knowingly false because it doesn't make any sense. It doesn't make any sense. How the hell is KJ supposed to know that she is telling a lie when she's supposed to know it's a lie because Toddy has photographs of her in Seattle? But Toddy herself says it might not really be a photograph in Seattle at that time. And so KJ is supposed to know for a fact that this post is true, to know that she's telling a lie. This whole thing doesn't make any sense. How is KJ supposed to know what is true and what is not true regarding where Tati lives, how is KJ supposed to know what is true and what is not true regarding where Tati lives, when Tati herself has said, I don't make every post. Sometimes I lie about the location. Sometimes I lie about the time. Sometimes it isn't when it appears to be or where it appears to be because I'm concerned about my safety. I don't want people to know my whereabouts. I'm a public figure in the public eye. So sometimes it isn't what it seems to be or where it seems to be or when it seems to be. How the hell is KJ supposed to know that what is true and what is not when Tati herself admits that sometimes she lies, basically? Because of this Instagram post, because of Tati making Instagram posts or whatever, she's taking photographs of herself in her apartment in Seattle. And so she knows that it's false when she says she lives in California because she knew about the photograph in Seattle, but you yourself said it wasn't reliable. How's she supposed to know what's true and what's a lie when you yourself say it's not reliable? And then one step more, her attorney then also knows it's a lie. How the fuck is her attorney supposed to know it's a lie when Tati herself says, well, what I post may not be true? And now suddenly we want to say the attorney knows for a fact what is true and not true, and the attorney is committing malpractice and is deceiving the court in some sort of active malevolent thing. The attorney knows what's true and what's not true and is purposely lying to the court in bad faith because the attorney knows they didn't live in California, because the attorney knows of the Instagram photos or whatever, which the attorney is supposed to know is true. Even Tati says you're not supposed to know what's true. So the attorney is actively, purposely lying and misleading the court. Bullshit. You can't have it both ways, man. You can't have it both ways. Yeah, I know I'm repeating myself, but I'm a little pissed off. When I say the same thing over and over and over again, it's because I'm kind of pissed. So I know I said the same thing 2 or 3 or 4 times. But I said it 2 or 3 or 4 times because it doesn't make any goddamn sense. And I'm trying to logic it through. And I keep hitting a logic error. You know, this is what, when I try to logic statements through and I reach an error, and I go back and I go back and I go back because it doesn't make any goddamn sense. I'm trying to make what is illogical logical, and it just doesn't work. And my brain just keeps resetting. And I'm a little frustrated. So yes, I repeated myself. Internet commentator since the chat is mad at me, apparently. KJ said she knew she lived in Washington based on official documents. But what? Some documents reflected Washington. Some other documents reflected some other things. Yeah, I mean, there were some business and corporation documents that reflected a Washington address, but that's not necessarily her only address. Or she could live in more than one place at the same time. It's not unheard of. Or it could be an address for one purpose, but not another purpose. That's not unheard of. So so KJ had the business documents from the Secretary of State that showed that the business was incorporated and showed the home address of these people and showed it to be a Washington address. Well, that's some information KJ had, sure. But is that the only information she had? No. It isn't the only information she had. And so, these documents certainly say that you're from Washington and live in Washington. Noted. But, there's other things beyond that, too. All right. I'm going to finish this out. Yeah. The chat does seem to get mad anytime I defend KJ. They got mad when I defended KJ in the original thing that I did the very first time. The chat does seem to get mad when I bash Toddy and defend KJ. I'm like, well, I'm just trying to, as best I know how, to apply logically consistent arguments and trying to apply logic consistently. And if Toddy makes good arguments, I say so. If KJ makes good arguments, I say so. I beat my head against the wall over KJ, guys, and her crap and her complaint. So, like, I'm not like a KJ fanboy, although some people seem to think I am. But, like, yeah. So I'm more than happy to criticize KJ and her lawyer, which I've raked over the coals. And then I read Toddy's complaint. I'm like, well, this doesn't make any sense. Why this doesn't, yeah. $5 from Sarah Mills. Seems like chat can't handle stuff that isn't 100% anti-KJ. Thanks for providing alternative perspective. I appreciate learning more. You know, I'm I have to call it like I see it. You know, like a judge will. I know once again I have to remind all of you that a judge does not and will not know any of the drama or background of these people, and a judge will not care about any of this like drama that you guys come in with. A judge comes in blind and neutral, and they're going to look at it evenly, and they may come to different conclusions than me. That isn't to say they'll come the same way I did or reach the same conclusions I did, because people think about it differently. As Emily herself pointed out, that's why she likes talking to different attorneys, because we think about it differently. But a judge is going to come and do it neutrally, and they may occasionally rule for KJ. Whoa, you know, KJ might even win in the end, guys. KJ might even win. I know, right? It's possible. I mean, she's got some really good defenses and in defamation that she hasn't brought up yet, but like KJ can win this thing. I'm sorry you guys hate her, but she might win. And then Toddy makes these statements. They're completely internally inconsistent, and I get mad at Toddy. And then the chat gets mad at me because I'm defending KJ and I'm her boy toy again. What can you do? What can you do? Okay, for instance, after publishing this defamatory pathos article, Paulson published a video named Whatever on May the 31st, 2019 on her YouTube channel, wherein she describes in detail some of the research she did on plaintiffs, including throughout her research of Washington Court and other public records. You know, just by way of aside, I'd really like to not have this be, I'd really like it to be possible to be as honest a broker as possible and still gain subscribers. I know I'd really hate this. There are a couple YouTube people of note who have a bias and they express things in a very consistent way, and that is in conformance with their bias, and people seem to eat it up and love it, and they get a lot more subscribers than me, and I'd like a lot more subscribers too, and I hope it's possible for this channel to grow. I wonder how many people are disliking and unsubbing right now because I'm not telling them what they want to hear. That's a bit distressing and depressing for me. Like, how many subs am I losing right now because I'm not telling people what they want to hear? So I guess I could just tell people what they want to hear all the time and I gain subs. So I really hope it doesn't come down to that. You know, I hope I don't have to completely sell my soul. Just days after publishing the video, Ms. Paulson published another video, and displaying some of her research in the video, Ms. Paulson showed a screenshot of a then recently filed corporate public records of a company with which Mr. and Mrs. Walsbrook are interested that disclose their address in Washington State as legal domicile. Right. So yeah, she had information that showed she did in fact have a document that showed an address in Washington. That is a piece of information that she had. Noted, right. She had that information. KJ knew. She had one document that showed this thing. Unfortunately, she also had other things that may have contradicted that. You know, she could have relied on that document. There's other things she could have relied on. you know. And just because they lived at one place doesn't necessarily mean they didn't live at another place at the same time, because you can live at more than one place. Okay. As such, Miss Paulson had published research. She was on direct notice at the time. She performed all her research and made them and their family members a target. These videos expressly identify as being crucial evidence of defamation. It's difficult to imagine a defense lawyer would not have viewed the same videos made by his client. There's other information the lawyer could have relied on. There's other information that they could have relied on. Even if the lawyer viewed the video, even if the lawyer saw the document, there's other information that suggests other things. Okay. Whoa, what did I just do there? Somehow made the document much bigger. All right. So, judicial notice is reserved for matters generally known within the territorial jurisdiction or capable of being accurately determined. High degree of indisputability is generally required. Yeah. It's only appropriate for facts that are not subject to reasonable dispute. Correct. You're looking for the most well-worn facts. Correct. Defendants have requested the court take judicial notice of Appendix B, which is a list of links of videos. However, review of Appendix B reveals numerous links are not actually videos of all. For the following items are not YouTube videos, thus rendering the request misleading and fatally defective. Okay, fair enough. It is not well drafted, which, is not exactly outside the realm of possibility. Fair enough. Further, courts generally deny requests to take judicial notice of extrinsic documents, including but not limited to text message applications, unverified websites, conversations in newspaper articles not being proper. Fair enough. Because the United States Court of Appeals for the Ninth Circuit has explained that court may take judicial notice of publications to indicate what was in the public domain, but not whether the context is true, courts have held to the extent a court can take judicial notice of press releases and news articles, it only can do so to indicate what was in the public realm, not whether or not it's true. Fair enough. It needs to be redrafted. It needs to be redrafted and clarified exactly what we're asking for. If we're taking notice that they exist, okay. If we're taking notice of their contents, okay. If we're taking notice of the truth, can't do that. Fair enough. It needs to be redrafted. Okay. The balance of Appendix B cites the videos which are not properly subject to judicial notice. The case law cited by defendants applies only to notice of written publications, not videos. Interesting. See some case stating judicial notice was appropriate for news articles, not links to news articles. Yeah, so the content, but not the link to the content. Okay, that's fine. I mean, I would think that a video qualifies as a written publication within the meaning of the law. So you can take notice of the thing, but not the link to the thing. And all they did was provide links, so maybe there's a problem there. But I don't think it's correct to say that videos are not written publications. I mean, as opposed to what? They're publications, and they're being recorded, so they're written. So, yeah, they're written publication, I would think. I mean, defendant's reliance on whatever is similarly misplaced. And also the court granted the judicial notice on documentary evidence as those documents whose existence cannot be determined. This district has determined a court may not take judicial notice of YouTube videos and photographs because there's a reasonable dispute concerning the substance and authenticity. Okay, fair enough. If you want to say that there's a dispute as to the authenticity of the document, then fair enough. Fair enough. They have to be authenticated. Okay. Defendant not only improperly requests judicial notice of videos without proper authentication, but also relies on the contents, many of which have been made unreliable and disinterested third parties, as a basis for made irrelevant statements. As stated above, it's well established the videos themselves as well as content are not proper for judicial notice. Please take careful notice here. The court that they're not even arguing that they're not evidence. We're arguing something much tighter. We're arguing judicial notice. So even if the court grants this and says they're not going to grant judicial notice, that doesn't mean that they're not evidence. It doesn't mean that they can't be used in court. There are other objections, hearsay, authentication, there's other things. But even if the court says no for this purpose, it doesn't mean it's no for all purposes. So you have to be careful there. It's like, will they take judicial notice of them? Probably not. Does that mean that they can't be relied on in court? No. That doesn't mean that. Maybe for other reasons, but, Don't misunderstand what's going on. We're just asking to circumvent a bunch of steps. We're asking to save ourselves time by if the court says no, we just have to do it at trial. We're trying to save ourselves time by just skipping all those steps, which we can do if it's reliable and authentic and blah blah blah. So we can skip a whole bunch of steps and save ourselves time. But if we can't do it the easy way, then we can do it the hard way. So that's fine, no problem. Yeah, don't sell my souls for views. Fair enough. You mentioned something about copyright there tonight. Would that be a different route they should take rather than defamation? No. I only mentioned copyright in the context of describing something that was a federal question. It had nothing to do with the content. It had nothing to do with the case at hand. I mentioned copyright because I was talking about jurisdiction, and I was talking about federal question jurisdiction and diversity jurisdiction, and I needed to give an example of something that would be federal question jurisdiction. So the example I picked of federal question jurisdiction would be copyright because there's federal issue. It has nothing to do with the case at hand. It was just an arbitrary example to pick of something that would be a federal question for federal question jurisdiction. So I wasn't saying like there's copyright issues here. I was just using it as an example because I was trying to, in that segment, I was trying to describe what jurisdiction was. So I'm like, here's what jurisdiction is. And then I said, well, here's subject matter jurisdiction. Here's personal jurisdiction, here's diversity jurisdiction, here's federal question jurisdiction, and trying to give examples. So it had nothing to do with the case at hand. It was just trying to describe what jurisdiction was. So now I mentioned copyright only to bring up, here is an example of federal question jurisdiction that exists in general, not with respect to this particular case. So, yeah. The content appears to be largely contain the uninformed and irrelevant personal opinions of individuals, of which there's no evidence to qualify their opinions as having any credibility, be given any weight, or otherwise presents any sense of reliability in the method by which the opinions were formulated. Rather, the video appears to contain nothing more than a motley group of gossips, attempting to build momentum to the gods of speculation. I like the writing there, that's cute. Is the contents of these videos which defendant is now attempting to ask the court to accept as indisputable fact. The court is forbidden to do that. Defendants lack any evidentiary basis for the vast majority of statements. To wit, no one has testified anything concerning any of these statements, let alone authenticity. Fair enough. Defendant's fact section is entirely reliant on the court reviewing hours of footage of people of unknown credibility, motive, education, bias. Fair enough. Quite literally, none of the subject matter for which they seek notice meets the standards. Fair enough. The following items are links to YouTube videos. Defendants rely on. Yeah, fair enough. So yeah, I would be very disinclined to grant judicial notice of this stuff. So, prove it in court, but yeah, I'm not going to give you notice of that because there's authenticity issues and it's also a little bit unclear what exactly is going on. So yeah, I'd be disinclined to, I would give it, I could imagine a situation in which I would give judicial notice of a YouTube video. In fact, I can think of a very specific example in which a court did take judicial notice of a YouTube video. I'm not even sure either of the parties asked. They might not have. I forget. But I can think of a very specific example where a court did take judicial notice of a YouTube video. The creators of South Park were sued for copyright infringement, federal question. They were sued for the what in the butt when Butters did that whole thing. So I said what in the butt? Yeah, I said what in the butt? All that crap. So because that was a real video by some guy. And South Park parodied it by having Butters do it. And, as far as, in so much as a cartoon can be a shot-for-shot remake of a live-action video, it was pretty close to being the exact same thing. So the guy who made the original sued for copyright infringement of South Park. And he didn't attach either video to his lawsuit. And I'm not even sure the defendants asked. So I might have been the court doing it on its own, where the court just says, okay, I'm taking judicial notice of taking notice of the original video and taking notice of the infringing video, because it's the most important thing in this case. These two videos that exist. I'm taking notice that they exist, and now I'm just going to do my copyright analysis on the back of it. So that's a very specific example of where a court did take judicial notice of a YouTube video. And then in case you're wondering how it panned out, the court ruled that there was no copyright infringement. And then the Court of Appeals also ruled there was no copyright infringement. It was a fun case. It was a well-written case because the court had fun with it because it was so absurd. Where the court was like, yeah, this is basically just a parody. They're basically poking it at an absurd. So I'm sorry that like it looks basically the exact same as the original, but it's making fun of the entire thing. And so yeah, no infringement. Copyright infringement denied. Denied. Yeah. Defendants have failed to lay any foundation as to why any of the items attached to the notice are subject to judicial notice. The defendants have failed to attach news articles as exhibit and are attempting to mislead the court as to the nature of facts. The facts section is not based on facts, only the opinions of third parties. No description or even reference of each video, fair. One must ask each link to determine what's valid, fair enough. They have not been authenticated, nor are they proper to notice. Subject B should be summarily disregarded. I'm inclined to agree. It's way too much. And yeah, I'm inclined to agree. And maybe come up with a better version. But I'll give you A. And I won't give you B. Personally. So I don't know some judges have different, it's a judicial standard, right? So like, will a judge do it? Who knows? But that's what I would do. And then it's just sign the certificate of service and we're done. So we have reached the end of T. We have done all the declarations. We've done all the motions. We've analyzed it. We yelled at Toddy a little bit and lost the chat and lost their love. And, and went from there. But that's okay. I hope everyone's having a Merry Christmas, by the way. It's still Christmas Day here for an hour and a half in the central time. So I hope everyone is still having a Merry Christmas. And I loved the pun of my own title here, Oh Christmas Tea. I thought that was pretty good. So I hope everyone enjoyed this. And I'll stick around for a couple minutes and ask a couple questions. And thanks for everyone who's become a new member, new supporter on all that stuff. I really appreciate it. Yeah. Yeah. So, yeah. Did I look at the attachments, the declarations, I believe? That's what we've been looking at now. We spent the last 2.5 hours looking at the declarations. Merry Xmas. I'm doing great. Thank you, Invo Boss. I appreciate that. Good job. We love you, says Susan. Thank you. I appreciate that. It's over. Well, we reached the end. There's nothing left to discuss. We reached the end. There's no more to discuss right now. I know Emily and I will be on next week, and we'll get into the weeds on the jurisdictional stuff, I think. But yeah, I know Emily had a much different reaction to the section that I repeated myself several times. And I don't begrudge her reaction, but I shared my reaction. And so I had a much different reaction than she did. And I found it to be, yeah. I did have a Merry Christmas, yes. 20 minutes left here for Christmas, fantastic. Katie's case might not make you grow like it has Emily, but might you grow to see some things like South Park case? Fair enough. Did I see the screenshots? Sure, we saw the screenshots in the things. Yeah, we showed them on screen. Who would win? I don't know. I mean, in a perfect case, I think KJ has the best argument. In a perfect case, in a perfectly argued case, I think KJ has the better argument. Because I think she can destroy the defamation, and the defamation is the core of the case. And I think then the other stuff falls away. So in a perfectly argued case, I think KJ has the better end of the argument. Now, with the way things are going right now, Toddy's looking a little bit better because KJ never moved to dismiss, and her actions. So Toddy's best cause of action. So I don't think Toddy wins on the intentional infliction of emotional distress. I think that's likely to get dismissed. The intentional infliction gets dismissed. I think what was the other one? There was 4 causes of action. The intentional one gets dismissed. The civil harassment stays. The negligent infliction of emotional distress stays. And what was the 4th one? I forget, but I thought it was a loser. So yeah, the negligent infliction of emotional distress I think stays. I think the civil harassment stays. And yeah, and if KJ had actually argued the defamation and argued it properly, I think it's the core of the case. So those arguments, which appear stronger than they really should, because what KJ's lawyer probably should have done, in my opinion, was to just destroy the crap out of the defamation case, and then it's the core of the case, and then like, you know, with your heart being carved out, you know, having this other stuff sitting around isn't going to really matter that much. But she didn't do that, so the arguments look stronger than they did. So yeah, I think Toddy's looking better right now. So that's what I think. 29 from another light. Do you think many of our judges are compromised and or in bed with China? No. No, I don't think many judges are compromised. I think most judges are pretty good. And some are pretty biased. Like we had the whole problem with Judge Sullivan with the Michael Flynn case, where he's coming to some very questionable conclusions. It seems to support a particular narrative, but you know, it was you know, I think most judges are pretty good. And then Melanie points out the other possibility, which is a fair point, Melanie, and thank you for pointing it out. There's a very, very strong possibility that KJ, because she opens her mouth and tweets and does stuff all the time, there's a very good chance that KJ undermines even further whatever case she has by continuing to talk. Right? Most lawyers will advise you to shut your mouth. Toddy has done a pretty good job of shutting her mouth. KJ less so. So there's a pretty decent chance that KJ will continue to undermine her case by opening her mouth. So that is a strong possibility, Melanie, as well. So as we're trying to score this. So in a perfectly run case where they made the best arguments and KJ kept her mouth shut, I think KJ would be better. In the present reality, where that is not happening, where they didn't make the best argument, and not so much on the keeping the mouth shut, Toddy looks better than she probably should. But that's where we are. Toddy looks better than she probably should. So, you know. Yeah, at the moment, that's where we're sitting. Emily would be proud. Thank you. I appreciate that. Eliza Main says, hi. Hi, Eliza. How are you doing? 24 left to go. 24 likes left to go. Yeah. KJ doesn't always listen to what's her best interest. Fair. I hit the like button as soon as I got here. I like hearing from both sides. Fair. And if Toddy screws it up, I was critical of Toddy in this very complaint. I mean, I made arguments against Toddy. I railed against Toddy when I thought it was needed. It's like, you know, if I think she's wrong, I think she's wrong. North Sea Hero says, if you want proof that I like you despite your unbiasedness, you took me to school over a super chat I did, and I was happy with it. So in a super chat, I still criticized because I thought it was the right thing to do, and it still got the support. So hey, there you go, right? Do I think attorneys are evenly matched? Not right now. I think Toddy's lawyer is much better. I have a personal distaste, which is a personal distaste for taking the lawyer under the bus. I think it's unnecessary and leads to complications. But other than that, I think that Toddy's lawyer, I mean, there's very little to criticize other than that one thing. It's well argued, well reasoned. There's a couple little mistakes, but nothing really to write home about. Emily talks highly about me. Thank you. KJ keeps digging himself in the hole. Yeah. If KJ won, should she get costs? I mean, I don't think there's any mechanism for costs in any of the laws I'm familiar with. I don't think there's any fee shifting statute that would apply. So in the event that KJ wins, everyone would pay their own costs, I would imagine. Bedroom eyes at 3,000 likes. Fair enough. I have some deleted tweets from KJ, and both Emily and Michael Saltz seem to think they're legally significant. Can I post a link and get your reaction to them? I don't believe that non-mods can post a link. So that's sit farther from a camera and wear a hat. Your viewership will explode. Well, if I sit any further back, I'd have to move the green screen, but I could do that with zooming and stuff. But fair enough. You think I need to move further back from the screen and be a little bit less zoomed out? I mean, I could zoom it out more. You think I'm too close to the screen? Do you think I'm too close to the screen? Do you think I should zoom it out more so it's not so zoomed in? Is this too much? I'm open to opinions. If you think it's too close, I mean, I'd have to adjust the green screen, so I can't do it right now on the fly. But if you think I should sit further back and have it more zoomed out, I'm open to that. KJ has committed perjury and deleted evidence. What punishment could she face? Well, I don't know that she's deleted perjury. As for deleting evidence, I mean, you can get sanctions in that, and you can have the inverse inference held against you. So that's a real problem. But I don't know about perjury. I really want KJ to win. However, it seems like she's cutting her nose to spite her face. If Toddy wins, the precedence of this case, it says is not good for commentary channels. Maybe. It's possible. It's possible. Framing doesn't look right when you're too close. Okay, fair enough. Yeah, this is the standard distance I'm at, but if you think it's too close, I could try something further away. What are the ramifications since KJ is still deleting even though she was told and put on notice not to? If she's still deleting even with notice, I mean, they have a consent agreement. She could be held in contempt. She could get the inverse inference, a whole bunch of things. I like the 20% cutoff to the slide a little, like 30% right because you generally look left for chat. Fair enough. Adverse inference, not inverse inference. Right, adverse inference. Yeah, right, adverse inference. So if you delete stuff, you can get an adverse inference. So that means that the court can say, well, we'll take it adversely, like it would hurt you. So we'll assume it's damning, and that's the reason you deleted it. So you can get the adverse inference that it says basically the exact thing you don't want it to say. Yeah. What's on my bookshelf? It's not really my bookshelf, so I wouldn't know. It doesn't apply to criminal law. That's correct. It does not apply in criminal law. Adverse inference is only in civil law. Correct. Yeah, but I thought the green screen worked out pretty well. I like the background. It was better than some of the other choices that we had. Some people seem to like the background, or seem to like the green screen. So I thought we'd try it out. I thought it worked out pretty well. I got the lighting to match pretty well, so it worked out pretty well. Yeah, I thought it worked out pretty well. It's a little bit neater, a little bit nice. Yeah, green screen works. I think it does work. I like this image. There were some other choices. I thought this one worked out pretty well. I think in the future, I'll try a little bit more zoomed out. So this is at like 29, so I'll try like 25 and try a little more zoomed out and see if that works. Yeah. Courtroom background would be cool. I thought about that too. In declaration, she lied about no employees. It's not clear that she lied. I don't know. And not research in Washington. I don't think that's what she said. And not knowing Toddy moved to Washington. It's not clear that she knew. We spent time discussing that. Isn't that perjury? I mean, I don't know that she lied about not having employees. I don't know that. She called Ahmad an employee. She called her husband an employee. It's not clear that she was using those terms literally. So it's not clear to me that she lied. It's definitely not clear to me that she lied about knowing. Oh, it's not clear to me that she knew that she lied about having fans in Washington. Yeah, it's not clear to me that any of those are lies. Yeah, it's not clear to me that any of those are lies. So when she said she doesn't have any employees, that might be true. I don't know. She had called her husband, I think, an employee, and she had called Ahmad an employee, but it's not clear that she was using those terms literally. I think she might have used them colloquially. So in a formal legal sense, does she have employees? I don't know. Maybe she doesn't. When she said that she wasn't unaware of having any subscribers in Washington, and they point out that one time on a live stream she acknowledged that she had a subscriber from Washington. Does she remember that to know? I don't know. It seems very odd to think that she would remember that. Like, yeah, one time on one live stream, I randomly called out a guy in Washington. Didn't remember that. So what, did she lie? Not clear. Knowing that she moved into Washington, we had a whole rant about that, basically, about her knowing that in Washington. It's not clear that she knew that. So I'm not clear. It's not clear that any of those statements are lies to me. It's not clear any of them are lies. So they might be, but it's not obvious. You suggest I turn off the green screen to impress everyone and get likes? How does that work? What do you mean to turn off the green screen to impress everyone and get likes? What does that even mean? Can I do a favor to switch the green screen to black for a second? I want to get a screenshot and it'll help me with mock-ups. You want mock-ups of me? No, I don't want you to make mock-ups of me. That's bad. One of her biggest states is from Washington. Well, unless she actually digs into her analytics to know that, I mean, she wouldn't necessarily know that. I mean, I have no idea off the top of my head where my biggest states are. I have no clue. I don't dig into my analytics all the time and keep it. I mean, I could find out. And now I probably have looked at one point in the past, but I don't know right now where I mean, it's not, she knows that? I don't know that she knows that. Lamp is 80s? Yeah, it's something. Is it clear they aren't lies? No, it's not clear they're not lies, but it's not obvious they're lies. It could be lies. I'm not sure. Yeah, we dropped all the states. Yeah, so Katie points out the obvious. Katie Compton says, we all dropped our states last night. Where do I live? Exactly, Katie. Right? Katie exactly raises the point. Last night, Katie said, I live from this. And I acknowledged it and read it on screen. Do I remember today what Katie said? I do not. You know, do I even remember every single state I read out? I remember some of them. Do I remember every single state I read out on stream from yesterday? No, I know I don't. So do I know that she was lying when she said she didn't know any fans in Washington? No, I don't know that. Yeah. Emily has mentioned Minnesota internet harassment law. How would you speculate those could come into the equation if the case gets refiled in Minnesota? I have no idea because I'd have to actually get into what the Minnesota internet harassment law is, to be quite honest. Yeah, I couldn't remember exactly. Yeah. Do I think this will get thrown out? I think there's a decent chance it gets thrown out for personal jurisdiction. I think there's a decent chance it gets thrown out for personal jurisdiction. But I'm not willing to go to the mat on it. And I'm interested to see what Emily has to think when we talk about it in depth. In this case, what happens next? Well, after the response, well, presumably the next thing that would happen is a decision from the judge on the motion to dismiss. Would presumably be the next thing to happen, and maybe some briefing related to that. So I would think the next thing that's likely to happen in this case would be a decision from the judge on the motion to dismiss, and probably denial. And if there's denial, then we get an answer, a formal answer from KJ, which might raise better defenses, and also maybe a countersuit would be the next thing after that, and then we'll go from there. The lawyers are concentrating on the law, not the drama. Yeah, concentrating on the law, not the drama. It's like, I'm interested in the law. That's what I do. Like, I'll know these people. I don't want to know these people. Not because I have anything against them. It's just not my shtick. And beauty YouTube is not my deal. So I have nothing against them. Just not for me. You know, I don't begrudge them their YouTube channels. But you know, I'm happy they're out there. Is there a refiling option if this case gets dismissed for personal jurisdiction? Sure. Yeah, if this case gets dismissed for personal jurisdiction, then yeah, they'll refile. Presumably in Minnesota. That'd be the most logical choice. What is an inverse inference? Adverse inference. So in a civil case, not a criminal case. So something that's adverse is hurtful. You know, it's adverse to you. Like an adversary, like a person who's an adversary. So an adverse inference. So in a civil case, if you delete evidence, the court can make an adverse inference. So the court can say, we're going to assume that the stuff you deleted it because it was really, really bad. So we're going to assume it was really, really bad. And now there's evidence that now we can take it as a given that was really, really bad. So it's the way of a court of saying, we're going to we're going to take as fact. We're going to take as fact this evidence that you deleted was really, really bad for you. And now it's a fact that it was really, really bad for you. That's an adverse inference. It's not a good thing. $5 from North Sea Hero. Have a slice of Christmas money from Houston, from the Hoosier State. Fantastic. What could KJ countersue for? I don't know. I have no idea. I hadn't really thought about it. What could KJ countersue for? I hadn't really thought about it. I don't know. Nothing pops up into mind. 300 likes. That's cool. How you doing, Rick? Thanks for helping Rick over here. Thanks, Rick, for helping us get to 300 likes and all the rest of it, man. Thanks for helping the channel grow, and thanks to all of you for helping the channel grow. Thank you very much for your likes and your feedback. And the 404 of you who are currently watching right now, thank you very, very much. That's a pretty decent turnout for me, for my channel. So I really, really appreciate it. Thank you, everyone, for your subscriptions and for your likes and for all the new members. We have 4 new members today. That's really, really awesome. New members today. We had, let me go back up in time and see if I can see the earlier one. Yeah, so new members today were Lady Law, Sarah Miles, North Sea Hero, and Veronica McNeem. Thank you very much, all 4 of you, for your membership and becoming members. And thank you to everyone who's a new subscriber. Thank you for all the likes. It is so appreciated. I don't think it would be in KJ's best interest to bring a lawsuits against Toddy due to the money. Expect no neutral response. Fair enough. And also, if she brings a countersuit, well, so that's possible. The one reason to bring the major reason to bring a countersuit for her is that she wanted to get to discovery, and if she has a cause of action that can survive a motion to dismiss, then she can get discovery for that. And apparently, one of the things she really wanted was discovery. So, yeah. Have a great weekend, Kurt. Thank you, superstitious oblivious bee. That is super helpful. Thank you. Guinea says, I'm sure she has employees. Well, maybe she does. Fair enough. Fair enough. Maybe she does. Maybe she did lie. I don't know. I don't know. This has to be costing KJ a shit ton of money. Yeah, so far, probably less than $10,000, but it's going to increase rapidly, probably. Cool. Well, we've been doing this 2 hours. Okay, we're doing this 2 hours, 57 minutes. So you guys got 2 more minutes, and I'm going to sign off before we hit the 3-hour mark. How about that? Since we've been 2 hours, 57. So I'll sign off for the 3-hour mark. What cause of action could KJ have? I can't think of any off the top of my head, but, I don't know. Nothing comes immediately to mind. Thank you for all the people who stuck with me, even though I don't tell them the things they want to hear. Appreciate it as always. Great show. Thank you very much. I doubt this will get dismissed. KJ will be in deposition for weeks. Possibly. I mean, if I had to take odds on the motion to dismiss for jurisdiction, I mean, I think she has a decent chance, but it's hard for me to project exactly because it's I can't know every area of law equally well. And some areas of law I know better than others, and personal jurisdiction is not something that I am as familiar with as some other areas. So it's like, this is something I'm weaker on, and I'm willing to admit that I'm weaker on it. So, I'm not 100% sure, but I think she has a decent chance. So what percentage is that? I don't know. I'd be interested to see what Emily thinks in terms of it. Bang my head? Well, I can't right now because I can't get to the wall. If I move the screen further back and stuff, maybe in the future. Thanks for answering questions. No problem. I'm happy to do that. I'm done reading. I hope I get a nice cold beer and have a good night. Thank you. And thank you all, and Merry Christmas to all. Will she have to go to Washington for a deposition, or if they can do it from Minnesota? They can do a deposition anywhere. It doesn't have to be in Washington. They can pick a form that's mutually convenient. And these days, they can do it over Zoom or whatever. That'd be fine. Merry Christmas, Uncivil Law. Caught you on Briquetta Law a few months ago. I've been watching ever since. Excellent, thank you. I'm looking forward to streaming again with Nick in the near future. Think she employs her husband for tax purposes? Possible. I know what Emily thinks, she does not agree. Fair enough. Emily might have a better opinion than me. Fair enough. I'm not. This is not something I'm willing to go to the mat for. So yeah, Emily might have a better and more informed opinion on me. That's cool. I don't mind being overruled on this one. All right, I see my 3 hours are up. To everyone here, Merry Christmas. I hope the new year brings you many tidings of good cheer. I hope it is a wonderful year and you get everything you're hoping for. And thanks again for all your love and all your support. It's been a real pleasure. Until later, my friends, cheers and goodbye.